After 2 weeks, Lordship.
Or friends only as an
Okay, eventually, yes.
one over the then go. 41.
Yes, Lordship.
Yes.
Kindly adjourn the matter, Lordship. Kindly fix the matter after 2 weeks, Lordship.
41 and the request made on behalf of respondents.
Yes, Lordship.
1 to 5 matters that differ to be listed after 2 weeks. And you have taken consent?
Yes.
Yes, Mr. Sharma? Consent of the council for the petitioner has also been obtained. Yes.
Also, I'd like to mention item number 50, 68 and 69. Lordship.
50, 68 and 69.
Yes.
Yes. What has happened here?
Mr. Ndeka is suffering from sleep disc, Lordship. That's why I've taken the consent of the other side. I've informed them.
50,
50, 68 and 69. 68 and 69 is connected, Lordship.
68 and 69.
Yes.
He is appearing in both.
In 69, we are not appearing. In 68, we are appearing.
But you have to inform the other side also.
Yes. They are
69.
69. They are.
Item E.
I've informed.
Right. 68, 69, they're all adjourned. Oh, which are the items again?
50, 50, Lordship.
50,
68 and 69.
50, 68 and 69.
Yes.
Adjourned. A request made by the council on behalf of Mr. Ndeka.
And they come.
The date we fix, Your Lordship. If it is not inconvenient on 8, Your Lordship.
8 is not possible. So it has to be after 15th August.
Lordship, fix a date.
18th August.
18 August.
Wait, please, Lordship. Lordship, I beg to mention item number 63 to 67, madam. Supply list.
Yes.
This matter may come after 2 weeks, madam.
Why?
In this case, madam, we are required some time to file affidavit, madam.
Who are we?
Respondent, madam.
Which
AFDC,
respondent?
AFDC, madam.
AFDC.
Madam.
How much time?
2 weeks, madam.
What about the consent of the petitioners?
We have already taken, madam. 63 to 69.
Yes, 63. Any objections?
But date may be fixed, Lordship, after 2 weeks.
It is fixed today.
Lordship. They can consent for
You
2
have
weeks.
given consent. Item 63 to 67 stands deferred to be listed after 2 weeks on a request made by MS as Setia. Yes.
Bless.
Kindly date.
Date, we'll fix it. Let them file the affidavit. You may file a reply.
Petition.
They are paying time to file their counter affidavits. Let them file it. Then we'll fix a date. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number Lordship 5, Your Lordship. Yes, the leading counsel Miss P in the charge is out of station for her treatment, Your Lordship. For her treatment, he is out of station.
Who?
P Bhattacharya, Your Lordship. Anjali Bhattacharya.
Item 5 on the request
Yes.
made on behalf of MSP Bhattacharya stands deferred to be listed after 2 weeks.
Next week, Your Lordship.
Next week. After 2 weeks.
Lordship, next week will be better.
Yes.
Lordship, item 53 and 54, Lordship. My friend is there. Let it fix on a hearing date, Lordship.
My friend has confirmed that today he has difficulty in the second half. May I pray that the matter will be taken away 12 Lordship if possible. The pensionary matter, Lordship 22 matter.
Let it remain, let us see.
May please, Your Lordship. Lordship, I am praying for listing of this matter, Lordship, in the admission column, Lordship. Matter pertains to non-payment of family pension, Lordship.
Admission matter.
Lordship.
List. On 6th of August.
Lordship, oblige.
Please, Your Lordship. I'm mentioned for withdrawal of matter, my lord.
Withdrawal.
Number 58, 59 and 60, my lord. Remember, the petitioners are not willing to further pursue the cases, my lord.
58, 59, 60.
Yes, ma'am.
on the request, on the submissions made by counsel for the petitioner, these items stands dismissed as not pressed. As it is submitted, the writ petitioner is not inclined to pursue the writ petitions any further with liberty. Dismissed as not pressed with liberty.
May I please, Your Lordship? I beg to mention for listing, Lordship, a pending matter, Lordship.
What stage, what
Promotion
matter?
matter, Lordship. Promotion matter, Lordship.
Promotion matter. For admission.
Admission. First,
First, that was not possible. It will be on 13th August.
13.
May it please, Your Lordship. I beg to mention item number 26 of the daily list, Your Lordship. Lordship, this matter was supposed to be listed along with contempt case number 759 of 2019 with pursuant to the order of this honorable court, Your Lordship, but it has not been listed along with it. For proper adjudication, it is required to be listed along with the contempt case, Your Lordship. If the Lordship allows, the matter may be listed along with it. Day after tomorrow.
Not day after tomorrow, goes to next week. On 6th item,
Item 26, Your Lordship.
26,
the
is
contempt-
submitted that, but why do you want the contempt petition to be listed together? Is there an order?
Yes, Your Lordship. There is an order.
Item 26, file this one.
The order is Lordship passed in the contempt case.
Contempt case.
Yes, Your Lordship.
Then you seek listing of the contempt case. You
Yes,
make a mention for listing of the contempt case. Why are you adjourning this writ petition to be listed along with this?
yes,
Do you have a mention memo?
yes, Your Lordship.
You have a mention memo with you?
Yes, sir. It's there in my bag, Your Lordship. I'll fill it.
So you make a mention. What is the item number? What is the
Item-
contempt case number?
Contempt case number, Your Lordship, 759 of
All
2019.
right. We are allowing it list on 6th. Contempt case. This matter we'll see as and when it comes up.
Deeply, Your Lordship.
May it please, Your Lordship. Lordship, I beg to mention for listing of a contempt petition, Lordship.
6th,
Obvious, Lordship. Yeah, for listing, Lordship, a contempt case for orders, Lordship.
6th.
May it please, Your Lordship. I have a pension matter, Lordship.
Huh?
Yeah, it is a pension matter, Lordship. Maybe listed on.
With what?
It is
Admission.
Admission. Yes.
Admission matter. All right. 6th.
High levels.
May it please, Your Lordship, I beg to mention for a listing of a writ petition, my lord. The matter pertains to ICC proceedings under the Posh Act, my lord.
Pertains to
Pertains to ICC proceedings under the Posh Act. Lordship, we kindly allow it to be listed on Wednesday.
Wednesday. All right. 6th.
Much obliged, my lord.
May I please, Lordship? I beg to mention for listing of the writ petition matter. On
For what purpose?
Admission,
Admission.
Lordship.
Admission. What is the subject matter?
Subject of petitioner for appointment on compassionate ground, Lordship.
Appointment of comrade. Did it come up on
Next week, Lordship, we need it.
let's see. Let's see. All right. Let us have it on 6th.
Lordship, read for listing and admission matter. Matter pertains to promotion matter.
Promotion.
Yes, madam.
Let it go to 11th. 11th August.
May it please, Your Lordship. Item number 16, 17 and 18, madam. Can it be adjourned for the week, madam? The briefing council is hospitalized.
16, 17 and
18. madam.
18. The request made by Mr. N.J. Dotto stands adjourned to be listed after 1 week.
I oblige.
Today's daily course list for motion item 1.
May it please, Your Lordship. Lordship, in this matter, the grievances of the petitioner has been mitigated. I humbly pray I may be allowed to withdraw this requisition.
Heard Mr. P.P. Medi, counsel for the petitioner. It is submitted that the grievances of the petitioner stand redressed by the respondents. Therefore, petitioner is not inclined to pursue the writ petition any further. Writ petition stands disposed as not pressed MSD Bora IPS for the Health Department.
I'm deeply obliged, Lordship.
Item 2.
We are a fan for an agent. If a
No, please.
be easier for you. To cite for you.
May I believe?
Yes.
Lordship, I have filed a contempt petition, Annexure annexure A, page 15,
Right.
page 15, para 20.
1 minute. You can see it. Judicial Yes, page 15.
Page 15, 15, para 20, madam.
Yes.
Annexure B, madam, page 170.
Where is the direction?
Madam, liberty, madam, would be
Para number?
para 20 and 21.
What is the direction?
Direction, madam, liberty, madam.
Huh?
Liberty, madam.
What?
ICDS project, madam. Promotion, madam. Oganbadi helper to Oganbadi worker, madam.
Your petition is dismissed.
Yes,
Then
madam.
why are you filing a contempt?
Madam, liberty, madam.
What liberty?
Madam, para 20, madam.
The contempt will not lie. You have filed some representation.
Yes, madam.
Have you filed?
Yes, madam.
Has it been decided?
Representation, madam. Yes. Re-examination, madam.
Have you filed a representation?
Yes, madam.
Has it been decided?
No, madam.
Not decided.
No.
So you have to file a fresh writ petition. Contempt will not lie. Read para 19.
Yes, madam. Dismiss, madam.
Then where is the direction?
Madam, liberty, madam. Would be-
You liberty given, you file. Have they prevented you from filing it?
Well.
Heard counsel for the
Withdraw it.
parties.
Liberty, withdraw.
The writ petition,
One.
the contempt petition is filed praying for issuance of directions that as the respondents have failed to carry out the order. So upon failure of the order, failed to carry out the directions contained in the order dated so and so, passed in WBC so and so. Upon perusal of the said order passed by the coordinate bench, it is seen that at para 19 of the judgment, the writ petitions have been dismissed. However, liberty was granted to the petitioner to file, to produce all relevant documents before the Director, Social Welfare, and to make a fresh and thereby a fresh inquiry can be undertaken. So the petitioner claims to have filed the necessary documents, but no order has been passed by the respondent. So under such circumstances, the contempt petition has been filed. Perusal of the order dated so and so, passed in by WPC so and so, reveals that the writ petitions have been dismissed and there is no specific direction to the respondents to carry out the inquiry made. However, it was left open to the authorities to look into the grievances upon the petitions being filed by the petitioners. So if that be so, if there is any further grievance, it may be open for the petitioner to have a fresh course of action. However, in the facts and circumstances of this case, contempt petition is not maintainable. Dismissed.
Item 3.
May I please, Your Lordship?
Yes.
My lord, in this case, my lord, Your Lordship may kindly taken up item number 4, my lord. She is a helper and that is a worker, my lord.
Item 4.
Both of them are terminated from the service, my lord, without issuing any notice, my lord. And in fact, my lord, in respective Anganwadi center also incorrectly mentioned at page 72, my lord, termination order.
When was the termination?
They were terminated 25/4/23. Page 72, my lord.
All right, we'll issue notice here. Heard counsel for parties issue notice. Mr. D. Bora, learned government advocate. Yes. Accepts notice on behalf of all.
In item number 4, all the respondents.
All. Therefore, notices are waived. Extra copies be furnished. Within a course of 2 weeks from today, respondents may complete instructions and file necessary affidavit. Same order in item 3 for government, MSU Sharma.
Yes, sir.
Yes.
Obliged.
Item 6.
I'm praying for a notice here because amount, some retirement amount has been given, about 20,000, rest has not been given.
4,91.
190.
Heard Mr. B.D. Das, learned senior counsel. MSM Bhattacharya appearing for respondent.
I am appearing for 1 and 2 only, lordship.
1 and
Municipal board notice has to go, lordship.
So the owner of the
Notice be issued on respondent.
Notice has to go.
Let notice issue. Returnable 4 weeks since MS Bhattacharya appears for respondent 1 and 2. Notices are waived. However, extra copies be furnished within a period of 1 week from today. Steps on respondent 3 and 4 by registered post ID as well as usual course within 1 week from today. List after
as
return.
well as justifying.
Dusty is also permitted.
Item 7.
Right.
May I please, the lordship. Petitioner before lordship, my lord, participated in the election process of Constable GD in Central Armed Police Forces, my lord. While submitting her application, my lord, in online, she wrongly selected, my lord, Delhi is the, my lord, domicile state and New Delhi is the domicile district instead of, my lord, state of Assam, and domicile district is Nagaon, my lord. Now, my lord, petitioner appeared in the computer-based written examination where she got, my lord, 70 above marks, my lord.
You selected, you filled up the form.
Yes, that is my computer-based, my lord, online form fill up, my lord.
Who filled it up?
Petitioner fill up, my lord. There is mistake, my lord. But that mistake, petitioner did not take any advantage, my lord. There are some judgment of, my lord. There is some judgment, my lord. Where,
Yes,
my lord,
any.
this court allowed, my lord.
So he wrongly filed his
Yes,
application, lordship.
Petitioner did not take
That
advantage.
therefore he was rejected.
Not rejected, my lord. Computer-based reason examination declared, my lord, and petitioner after came to know Highland representation, my lord. Petitioner came has
You
not been
filled up
rejected.
a form. You wrongly filled up the details.
Yes, my lord, that is true, my lord.
That is true. Then whether you had done it unintentionally or deliberately, how does one know about it? How will the authorities know about it?
Petitioner, other information, my lord, regarding my lord, address, my lord, other things, all are correct, my lord.
Maybe, but you filled up. You wrongly filled up the forms. Immediately, when did you intimate the authorities that this information has been
Yes,
wrongly
my lord,
filled
that
up?
is, my lord, kindly see my representation, my lord.
When
On
did you
page-
fill up the form?
Page 68, my lord.
When did you fill up?
Yes, my lord. Form fill up in the long back, my lord, but
Then
petitioner came to know after, my lord, declaration of result of computer-based written examination. Immediately she filed, my
that
lord.
means she is not careful. You have to be careful about it.
But there are some orders, my lord, in the same recruitment process, my lord,
Hmm.
wherein this honorable court as well as other high court.
Let us see.
Yes, my lord.
You did not mention when you filled up the form.
The case of Asmat Ali, my lord, that is our high court, my lord. This is also, my lord, recruitment of Constable GD in Central Armed Police Forces. Asmat Ali. Date of birth was wrongly filled up, my lord, and her candidature was rejected subsequently, my lord. At that point, she approached the court, my lord.
Let them examine it, you examine and see.
My representation may be considered in view of the, my lord, decision of the student as well as other high court, my lord.
Notice have to go in this stage, Lordship, otherwise.
Since recruitment process is going on, my lord, notice may be, my lord, they may consider my representation.
Why don't you get instructions on the face of the judgments?
His judgment, Lordship.
He's relied on some authority here.
I will give the,
You give a copy.
my lord.
You have only one copy.
No, I have to.
Give a copy. Yes. Third counsel for parties, MS S. Gorwa, learned CGC, praise for is permitted 2 weeks time. 2 weeks?
3 weeks.
3 weeks time to complete her instructions on the prayer made by the petitioner that the domiciles,
Domicile state and domicile district.
state and domicile state and domicile district of the writ petitioner was wrongly filled up in the form, which came to be detected subsequently, and the petitioner did not take any undue advantage of the same. The petitioner therefore seeks liberty of the court. He seeks a direction from this court that the authorities does not reconsider the case of the petitioner by recalling the rejection order, as these particulars do not give any advantage, undue advantage to the petitioner, as these wrongly filled particulars do not give any undue advantage to the petitioner. List again after 3 weeks. Extra copies be furnished within two working days from today.
Date will be fixed.
All right, after 3 weeks, 20 August, list on 20 August.
In case of the petition not rejected, my lord. Not
We are asking her to get her instructions.
obliged.
Item 8.
Sir, the petitioner was granted the voluntary retirement in the year 2010, my lord, but he could not avail it because of his mental illness and as well as physical illness, my lord. Now he become recovered, my lord, and he submitted his application, and it is not been considered. So my humble plea notice to me at this stage, my lord.
You're suffering from hepatitis.
Not a mental disorder, he was, my lord, almost mad, my lord. And he was roaming in the road, that was the condition. Now he has recovered.
May I please, your lordship? Your lordship, I'm appearing for the bank on behalf of PK, your lordship. We will take instruction.
You take instructions. We are not issuing notice at this regard. Counsel for parties against so represents the bank. Petitioner submits that because of mental illness that he suffered at the relevant point in time, he could not avail the voluntary retirement of the writ petitioner, and voluntary retirement accepted by the bank authorities. However, now that he is recovered, he is represented before the authorities, which have not been considered by the bank authorities. MS so will obtain instructions in the matter. Extra copies, sufficient extra copies, will furnished within 2 working days.
Item 9.
May please. My lord, the husband of the petitioner was appointed as works as employee on 4/6/1992. He died in harness on 13/2/2024, my lord.
This will issue notice.
Yes, madam.
We will issue notice. Learned counsel for the issue notice written for 4 weeks. Mr. Hardhor appears on behalf of
All that, no,
Financial.
finances.
this is the new name of the department. What is the new name?
Look, Nirman Vibhag.
Lok Nirman Vibhag.
That's a new name.
No, it has been there
It
since
can be,
my lord.
yes, PWD also.
Both, man.
Respondents 1, 3, 4, and 5. Mr. A. Cholia appears for respondent number 2. Mr. Cholia, you are appearing for respondent 2.
Respondent to finance, my lord.
Since the councils represent the respondents, notices are waived, extra copies will be furnished within a period of 1 week. I'm not list after the returnable date.
Lordship's name may be reflected in the court.
Names of all standing councils be reflected in the court list by the registry.
Amen.
Supplementary course list, motion item 56.
Kindly pass over the meter for the time being, Lordship.
Well,
As Botago is on legs, Lordship.
Huh?
As Botago is on legs, Lordship, he is arguing in this.
timing.
Daily course list, 4 orders, item 10.
May I please, Your Lordship? My lord, this is an inquiry report was regarding date of correction of date of birth. Already 28 years back, my date of birth was corrected as an officer by the irrigation department, and subsequently the judgment has been passed by the honorable. Suddenly on 8/12/2016, they have removed me, compulsorily retired me from the service. That by as per HLC certificate, my date of birth was 2015. Because Lordship, kindly see paragraph 20 of the judgment. Paragraph 20 of the judgment, page 28. As per that judgment, Your Lordship had already issued a notice to them that they have violated the judgment on order. Paragraph 20, my lord.
No, in this case, why is it for orders? Some order was supposed to be passed by the authority as per the last.
Lordship, in
And,
fact, there is an
inquiry
inquiry.
report was submitted. And after about more than 2 years, it is as per this paragraph, it is specifically mentioned.
We are going by the last order, 18/7.
Yes, Lordship.
18/7.
Lordship, after the report of the inquiry
Consequential
committee, Lordship, there should be a consequential order, Lordship. That is not done by the authorities, Lordship. I've already instructed them, Lordship, to pass a consequential order. But the new incumbent has joined, Lordship, in this. Both the respondents are retired, Lordship, now, Lordship. So anyway, Lordship, the new incumbents will also may pass the order for consequential.
When?
Lordship may fix the matter after 2 weeks, Lordship. In the meantime, they will pass the consequential order, Lordship.
My lord, 2 dates have been elapsed. Already 2 opportunities were given for consequential report. Actually, my respectful submission that inquiry report, it has got no legal validity in the eye of law. Initially, but it has been passed after, on perusal of paragraph 20, Your Lordship will find that a second opportunity was given to them.
Paragraph 20 of?
Paragraph 20, page number 28. Lordship, kindly see, kindly. No, they may submit consequences, but this is a very important.
Yes.
May I read? It is iterated at the cost of repetition. The case herein is that the employer of the employee, that is the petitioner, has sought to refix the date of birth of the petitioner by changing the same from 23/1957, already recorded in the service book of the petitioner a long year earlier, to 2/1/1955. As has been observed above, the state has the authority and the power to refix the date of birth of a government employee, even though a different date was accepted by the government at the time of appointment, but the same can be done only after an inquiry. It is thus up to the state respondent to decide about the further course of action in the matter. If a decision is taken to proceed with the inquiry, then the state respondents are at liberty to proceed with the inquiry from the stage where the infraction had occurred and complete the inquiry by following the mandatory procedure laid down under the rules, but the same must be completed within a period of 3 months from today. That means from the 30/8/2022. Considering the fact the dispute originated in the year 2016, any decision in relation to recovery on the ground of alleged overstay in service by the petitioner will abide by the findings and decision arrived at such inquiry with regard to the date of birth of the petitioner. It is provided further that in the event the state respondents take a decision that there would be no further inquiry, then they should proceed the matter of pension and other retirement benefits of the petitioner by taking the petitioner date of birth as 2357. That is already recorded 28 years back. And thereafter, upon finalization, disburse the entire dues to the petitioner within a period of 2 months from today. Now, Lordship, on perusal of the inquiry report, it has been submitted, it has been prepared on 3/11/2023. That means after about 1 year, 2 months, 4 months from 3/11/2023, that is with effect from 38/2022. It is a clear violation, deliberately and willfully that they have violated. At least they should give the honor to this honorable court. A person, he has been, otherwise also he has been deprived from his legitimate right to receive the provisional pension for last 9 years. And he was compulsorily retired without giving any opportunity. And that's why that order has been set aside by this honorable court.
What do you say, Mr. Vaidya?
Lordship, we have to go then to the merits of the writ petition, Lordship, in that case, Lordship. Lordship, we have passed the inquiry, there is an inquiry committee has passed an order saying thereby that, Lordship, his actual date of birth is 1/1/55, no, and not 31, Lordship, 57, Lordship.
And another very
my
important
friend is at liberty to challenge the inquiry report, Lordship.
No, but where is the inquiry report?
Lordship, it is in the record, perhaps.
Only on 25/6/2023, they have submitted my lawyer.
There is a delay in, Lordship,
After about 22 years.
completing the process, Lordship, nothing else.
When
And there
was
is
the-
no cooperation from the part of the petitioner in the inquiry loss committee.
That is the completely wrong.
He is avoiding the inquiry loss.
Never. We have received a letter, my lord, on 4th of October 2023, suddenly. In the meantime, we have prepared contempt case, and on 5/12, I have received the letter on 5/12/2023 that I will have to appear for the committee, before the inquiry committee on 12/10/2023. Then in the meantime, I have filed the contempt case. They have admitted here in first paragraph here, Lordship, on perusal of this, so the first paragraph, your Lordship will find. I have given due respect to them after receiving this letter.
But, but now the inquiry has been completed.
Lordship.
And there is a strong contradiction on the third party roads. On scrutiny of the service record, they have not found the affidavit. That is completely false. Already they have admitted in our case in paragraph 15. No? 15 by learned this honorable court has passed the.
No, your contempt petition is filed on the ground that this order has been violated.
Violated.
But they have now completed their inquiry. Which copy of which is available here?
This inquiry report has been submitted to me only on last 25/6/2022.
All right. Now,
Then your Lordship had made inquiries that why you have not filed the consequential report. For two times they have given consequential report. Because in the second part, your Lordship, they have.
May I request my
there is a strong
contradiction.
contradiction. Then in service record, on the basis of the affidavit, my date of birth was corrected 28
what
years.
was the inquiry report? What was the finding in the inquiry report? Was it for recovery?
Not, Lordship, regarding his date of birth. Lordship.
Now, after that,
Yes, the consequential order has to be passed, Lordship.
for recovery.
Lordship, for recovery and not his pension and etc. Lordship.
So, but inquiry report, his
That part
pension
also
papers
was
have been resubmitted.
Were resubmitted after refixation as per AG's observation, and his pension case was settled by AG after recovery of excess drawal of monthly salary from so and so.
That is also wrong, madam. Because already set aside. That
Due to
part,
wrong
as
fixation
per
of pay
Rafiq
from
Masih,
the
Rafiq
committee
Masih's
could
case,
not found
honorable
anything.
court has set aside. But in the event of a proper inquiry would have been done, then a matter would have been done other way.
You get the order passed immediately because you are under contempt.
Lordship. In fact, Lordship, the earlier incumbents are no longer holding the post. Lord. They are
Whatever it may be.
Lordship,
You know how the law
Lord.
contempt operates.
Lordship.
And another point, my lord, superintendent engineer who had recorded by service in 1988 in testful, he was not examined by them. I was not given any opportunity.
That you challenge the inquiry report. We are now in contempt.
Yes, yes, inquiry report is violated.
Inquiry report violated, you challenge the inquiry report.
Yes. It has been passed, my lord, after about 2 years, not within 3 months. That is my respectful submission.
Third, counsel for parties. In terms of the directions contained in the order dated so and so, passed in WPC so and so. Mr. N. Upaithai, learned standing counsel irrigation, submits that the inquiry report has been, inquiry committee was constituted and the inquiry has been completed. He has placed a copy of the report. However, pursuant to the inquiry, the consequential order required to be passed has not been passed. As who is to pass? The chief engineer.
Chief engineer also.
As the chief engineer, as the earlier incumbent had superannuated and a new incumbent has joined. He therefore prays for how much time? 1 week, we'll give you 1 week.
2 weeks, Lordship.
Not 2 weeks.
Lordship, give me 2 weeks time.
Not 2 weeks. You are in contempt. You have to get whatever you want to do, you do it.
Not.
Why are they sitting over there on order of the court?
Lordship may pass 10 days time, Lordship.
Considering that the court is in session of the contempt jurisdiction. And on the request made by the standing council, we permit further 1 week's time to the standing council to carry out the directions contained in the judgment and order dated so and so, passed in WPC so and passed all necessary orders as contemplated in terms of the same direction. Let this matter be listed immediately after 1 week.
Or 10 days, Lordship, let it be.
On 6th.
My lord, just regarding they have asked for 10 days. Actually, I'll have to leave for Delhi for my treatment on 6th August. I have no objection. An opportunity should be given. I have no objection, my lord. It may be fixed on 22 August.
22 August.
22 August, my lord. I have no objection. They may submit at least 5.
Accountant General.
I am compelled to go for I have to go for my own development. Sorry, my lord.
Obliged.
Sufficient opportunity to see the bosses.
Item 11.
My lord, the direction here is to give the benefit of minimum pay scale to the petitioners who are serving as a master role worker.
May I plead your lordship? Okay, as per my instruction, the order has been complied, your lordship. This is that.
Which order is this? 8-5.
My lord, at 5/2024.
Etu busai libo pare. Na, etu. Need to even a cycle.
Allowed. All three.
He has been complied with.
My lord, we haven't received the money.
Have a look. Show it to her.
There's a-
It has been complied with. Heard counsel for parties in terms of the directions contained order dated so and so, judgment and order dated 8/5/2024, passed in WPC number so and so. The petitioners were permitted, the respondents were directed to give the benefit of minimum scale of pay to the petitioners. Stop that order not being complied with, the contempt petition was filed. during the pendency of the contempt petition, it is submitted by MSR Deka that the said order has been complied with, and the same is communicated by order dated 17/7/2025. Stop. A copy of the same is placed before the court. The said communication shows that the incumbents, namely the city side of the Tinta Naam likha hai. The writ petitioners. Writ petitioners have been allowed to draw the minimum scale of pay as approved earlier by finance within bracket EC department by the letter number so and so dated 16/9/2021. In view of the submissions made by the respondent counsel and in view of the communication dated so and so, it is evident that the directions contained in the order dated so and so stood complied with. Stop. Taking into consideration the submissions made, the court would not like to proceed any further with the contempt petitions. Accordingly, the same stands closed. Notices issued are not recalled.
Item 12.
Yes, did you file any affidavit?
Your Lordship, I am appearing for respondent number 4. I have filed an IA for deletion of my name, Your Lordship. I have been wrongly arrayed as the party respondent in this case.
Who are you?
Your Lordship, I am a financial institution based in France, and I undertakes sponsoring and financing of all development works as per the requirement of the French government. And I actively work in Asia, Middle East, and all this part of the country. So a project in the Assam was financed by me. I sponsored the project. It's related to biodiversity and forest development. That was my only role. So there is no other role in it. And now there was some dispute with respect to some contract between the petition and the forest. So they have arrayed me as a party respondent. So my only prayer before this honorable court is that as I have been wrongly deleted, I have nothing to do with it. There is no relation between me and the petitioner. So
You're arrayed pursuant to an order passed in the IA.
Yes, Your Lordship, that the petitioner has filed. Without any reasons, Your Lordship, because they have no grievance against me.
You file an application for recall of that order?
Your Lordship, I have not challenged that. That is not required because I filed an IA saying that I have no relations with that.
But that is your relation in the litigation is in pursuance of an order passed by the court. Unless you take steps to recall that order remains. Where is the scope to pass another order saying that you are not required? Nobody invited you. You are here because of an order of the court.
And at the instance of the petitioner who filed an IA.
The order is passed that you are a necessary party. You are here. Now you are filing an IA saying that you are not a necessary party.
Correct, Your Lordship.
So that order has to be recalled.
In fact, from the perusal of the entire requirements,
whatever it may be, these are the procedural aspect. Whether you are required, not required, we don't know. But you are found to be a necessary party by virtue of the order of the court. So that order remains.
I'll file that, Your Lordship. I may be granted some time to file that. If I agree.
Yes.
We don't have any objection, madam.
Then why did you array him?
The respondent number 4.
Who arrayed the respondent 4? In your original petition, there were 3 respondents.
Yes, ma'am.
You brought him in. Why?
Because respondent number 4 finalized the biodiversity.
Then you, at your instance, the court passed an order. Now you're saying you have no objection if the names are struck off? Which means you wrongly submitted before the court that they were necessary party?
Yes, Your Lordship.
No, my lord, they have,
Yes.
They have
no role. They
have no role in the day-to-day monitoring or conduct of the agency.
Where is that order of the court?
18, 12,
18, 12,
2000.
2024,
18?
12, 2024.
May I submit your lordship? I think that will not be there. Order to 9 second court record.
1812, is it not here in your IA?
No, lordship, the order is there.
You're not enclosed in the IA. No, this is an order passed in the writ petition, IA orders. Order passed in the IA.
Yes, your lordship, I have the lordship. Unnecessary party को avoid petition.
एक भी इसी सुनिए तो नहीं। तो दोनों को
कोई नहीं wrongly police or case pending.
This is the order 1812. You filed an application for impleadment of this agency. We dismiss this IA or you withdraw it? Your IA?
Your lordship, let it remain. I'll file a recall order because the agency is based in France. So I have to vet the draft the application, send it. Then again,
This IA you have filed seeking, praying for an order that you should be declared to be not a necessary party. But this does not pray for recall of the order.
no, your lordship. Because that was filed at the instance of his.
You file, you amend this IA. You amend this IA or you file and
Yes, your lordship.
we'll take it up accordingly. At the request made by the council for respondent 4, Mr. R. Sinha, matter stands deferred to be listed after 4 weeks. He submits that the respondent, newly impleaded respondent 4 on who is represented by him is not at all a necessary party. And therefore, an appropriate application, appropriate steps will be taken for recalling of the order dated so and so, passed for arraying the newly impleaded respondent. Mr. So and so appears for the writ petitioner, Mr. D. Boy. This is the forest or what?
Yes, your lordship.
Forest. The Uwe appears for the Department of Forest. List after 4 weeks.
Deeply
Item
apologize.
13.
Please, your lordship. And the matter pertains to my lord family pension. The petitioner husband, my lord Babulal Bormon, my lord, was my lord initially appointed as a works as Khalashi in the year 1987. Thereafter, his post was my lord upgraded to my lord section assistant in the year 1999, my lord. And my lord, by order, my lord, dated 7/10/2005, my lord, the post was sanctioned and my lord regularized. At page, my lord, 45 is the list of the my lord 92% whose name was my lord regularized. As at page 45, my lord. Of my additional
Any reply file?
No, my lords, the Dimahasa has to reply, my lord, but we have also received instructions, my lord. These is that regulation was cancelled by the finance department.
That is the my lord under challenge in this writ petition, my lord.
So you complete the pleading.
My lords.
Rule has already been issued in the matter.
Yes.
You complete the pleadings.
My lords, I received this instruction on 19th. I'll file the affidavit.
Heard counsel for parties. By order dated 2024, rule was issued in the matter. Meanwhile, Mr. D. Gogoi, learned
PhD for
standing counsel PhD, and Mr. B. Sharma, correspondent number 6, enters appearance on behalf of the respondents, and Mr. Gogoi submits his received instruction. We'd like to file an affidavit and bring it on record.
Well.
Praise for 3 weeks.
3 weeks.
3 weeks time list. Again, after 3 weeks for hearing.
Obviously. All right.
Item 14.
Of 4 orders could be. Yes.
Should kindly fix the matter for hearing.
Yes.
Kindly fix the matter for hearing. Lordship, kindly fix the matter for hearing.
For hearing. By order dated 2012-2024, rule was issued. Have you filed any?
Yes, Lordship, we filed our affidavit. On the last occasion, it was not on record.
Since the pleadings have been completed, matter be listed for hearing in the usual course. Yes.
Item 15.
Dice code.
Yes, madam.
Then
I got a report from the Pharmacist my lord, stating that for 8-9, the said dice code was in the name of Mamorjan only, not in the name of the repetition of school.
but your documents that earlier said that it is there. Only 1 year was missing.
For 8-9, for the repetition of school, primary November, for 8-9, there was no dice code, my lord. So the dice code allotted to Mamorjan SSK was corrected in the name of primary November school, my lord. That was the report from the district office, my lord, page 81. Page 81, my lord.
Yes. Yes.
Last but second paragraph, my lord. So finally, it can be said that as the school code 0416911 was initialized in 2006-7 by then ADC, DMC and allowed Kawamari Nopomo LP school for the same academic year by the authority concerned, and moreover, no SSK is running presently. Kawamari Nopomo LP school may claim the dice code of 0416911 instead of Mamorjan SSK, which has no existence, and hence the name can be corrected in DICE database as Kawamari Nopomo LP school instead of Mamorjan SSK. So it was the observation of the district officer that since Mamorjan SSK has no existence during that period, my lord, so their DICE code can be corrected in the name of Kawamari Nopomo school. But practically, my lord, Kawamari Nopomo has no dice code for the year 8-9, which was the requirement under the 2011 Act, my lord, to have the dice code for 8-9.
This was already before the writ court.
Yes.
And what is the present position that you are placing before the court?
Mediation, my lord, already my lord corrected, my lord, page 82.
81 says,
My lord.
so-and-so court in so-and-so year was allowed to Kawai Mari. Who is Kawai Mari?
The writ petitioner, madam.
Writ petitioner.
My serial number 2, my lord. Kawarimari Nopoma LP School has submitted dice for academic years 2006, 2007, 2000, 2008, 2000, 2009, 2010, 2011, 11, 12, 13, 12, 13, except the academic year 9, 10, bearing dice code number so and so. Kawarimari Nopoma School initialized in the year 6, 7, duly signed by ADC and DMC contains same code in the list of recognized venture school initializers. So finally, it can be held that school code so-and-so was initialized 2006, 2007 by the ADC and DMC and allowed Kawamari Nopoma School for the same academic year by the authority concerned. And moreover, SSK is running presently. Kawamari Nopoma School may claim the dice data so-and-so instead of Mamorjan, which has no existence, and hence name can be corrected so-and-so.
Now,
And-
this letter, has it been recalled?
No. Till date, no, my lord.
Then
But and they are corrected, my lord, by order dated, my lord, 28/4/2016, page 82, my lord. But my information, my lord, after this report, my lord, they are now going to recall this letter, my lord. This present status of.
so you want to recall, you recall, that is your call. You don't know. You want to recall, you recall. We are not giving you liberty, nor
Yes.
are we advising you to do anything.
Yes, yes.
But why have you filed a review therefore?
Review is filed, my lord, because
That counsel for parties, no merit in the review petition dismissed.
asked, obliged.
No grounds to review.
Item 19.
Please, Briggs. This matter pertains to regularization. The petitioner has filed this petition for regularization. This honorable court has already issued notice and has also given me interim protection that my services would not be dispensed without the leave of this honorable court. May I refer to Millard's order dated.
Why have you filed the IA?
That IA has now become infructuous because the process of examination is now over.
2206 has become infructuous.
Please, because
IA number
examination is
also
over now.
become infructuous as submitted by the counsel for petitioner. Therefore, the same stands dismissed as not pressed.
May I praise something yet?
Yes.
Because counter affidavit or reply affidavit has also not been filed. So they may be directed to file within 2 weeks so that at least there is a closure of this matter.
So who's appearing for the respondents?
Sorry, it was here, my lord.
Who is that?
SP Chaudhary, my lord.
SP Chaudhary. Writ petition be listed for some writ petition. Writ petition be listed for admission after 2 weeks. Yes.
2021.
I'm obliged. But any fixed statement?
Because they have not filed a counter. Let it be filed.
I'm obliged.
I is for substitution, my lord. Petition number 2, Jawaharlal Chakraborty died.
Any objection? Heard. IA. Heard. This application has been filed by the legal heirs.
Petition number 2, Jawaharlal Chakraborty.
The application is filed by the applicant, who is the wife of late Jawaharlal Chakraborty, who was writ petitioner number 2 in WPC 18 of 2017.
17.
So it is submitted that during the pendency of the writ petition, the petitioner number 2 expired on 9/3/2025, leaving the applicant's wife as the sole legal heir. So it is submitted that, what is the claim in the writ petition?
My lord,
What is the claim in the writ petition?
claim in the pensionary benefits.
It is submitted that since the claim, the writ petition is for the pensionary benefits for the services rendered by the writ petitioner number 2, the right to sue remains, and therefore the, notwithstanding the death of Jawaharlal Chakraborty, the reliefs claim in the writ petition are required to be pursued by the applicant, who is the sole legal heir. Stop. Prayer made, it is therefore submitted that the legal applicant be substituted as a legal heir of late Jawaharlal Chakraborty. Stop. The prayer made is not objected to by the respondents. IA therefore stands allowed, disposed of. In the writ petition, then you write, in view of the order passed today, the petitioner directed to file amended post title before the registry. And in the writ petition, you write, in view of the order passed today, applicant or Nampudi so and so is substituted as a legal heir in place of petitioner number 2, Jawaharlal Chakraborty. Stop. Petitioner will file amended post title within 2 weeks from today.
Well, right.
List again after swearing.
Okay.
Mr. NS Zari for
2 and 3, my lord.
2 and 3, Mr. For the finance, and Mr. Bhor for respondent.
Okay.
Item 22.
May I tell you?
Yes.
This application is for impleadment of the opposite party as contempt now.
Opposite party.
Your lordship.
Order not yet complied with.
No.
But some instruction I have received from the DC, they have already returned to the treasury office. But I may be given some time. The present income with this transfer. The deputy commissioner, who is a party here, he was transferred recently. I have to get the instruction. Kindly give me some time.
And now what to do with the IA?
Lordship, because
Copy is not with me. Yeah.
IA has not been served.
No,
lordship.
not
Without serving lordship, I cannot do this. How can it?
possibly it is not given to me. Remove the IA. Keep the IA.
IA for implement of commission of the changes.
Okay.
You give him a copy if you have now.
Lordship,
Do you have a copy?
only one copy.
Only one copy.
Yeah.
He gave me.
You give him a copy, we'll take it up at 2 PM. 2 PM.
Maluk,
Give him a copy.
lot.
Yes. Good. 200.
Supplementary course list, orders item 57.
Here is your lordship.
Yes.
As per order dated 26/5/25, service report on respondent number 5 was awaited. Meanwhile, by order, the Lazima's report 25/7/25, service on respondent number 5 was
As-
completed.
As per Lozima, as per endorsements of the registry dated 25/7/2025, service on respondent number 5 has been shown to be completed. Stop. Anyone for respondent 5? However, none appears for respondent 5 when the matter is called. Mr. D. Bora appears for
1, 3, and 4.
1,
3 and 4.
3, and 4. And who's there for finance? Mr. Nayok appears for finance department. And Mr. Or for cultural. Respondent number 4.
Regarding respondent number 7, my lord,
Hmm.
just somehow left out. So maybe I'll have to take steps in respondent 7 also within 3 days.
Petitioner submits that steps on respondent
Normal
number
order.
7 could not be. No, respondent 7, Mr. Nayok appears. He's for.
7 lot.
He appears for.
Treasury office.
Treasury office. The grievance of the writ petitioner is that the petition, the pensionary benefits payable has now been released. Let the respondents complete their instructions and file necessary affidavit if so advised within 3 weeks from today. List again after 3 weeks.
61, 62.
If service upon respondent number 6 is everything in item 61.
Await service report on respondent number 6. This is in item number
61.
61. In item 62,
Lordship, the affidavit.
the affidavit has been filed. You want to file a rejoinder?
Lordship.
Petitioner seeks liberty to file rejoinder. Both the matters will listed again after 3 weeks. Mr. Rai Botaku for Forest, Mr.
THM. T.
T. Gugoi for
Respondent number 6,
respondent 6.
item number 62.
In item 62.
Okay.
Delhi coast list, admission with notice served, reply not filed, item 23.
With you, Your Lordship, I'm appearing on behalf of Advocate Pavitra Saikya, sir. Your Lordship, we may be granted some time to file our reply.
Yes. Petitioners are permitted. How much time do you want?
Your Lordship, 2 weeks.
Praise for 2 weeks' time to file reply to the affidavit filed by the respondents. List again after 2 weeks, Mr. Dhor
2, 3, and 4,
and Mr. Dotto appears for respondents. 2, 3, 4.
And for 1.
For 1. Mr. Dotto for 1 and Mr. Dhor for 2, 3 and
4, my lord.
2, 3 and 4.
Our name is not reflected in the party.
Make a note of it. The registry will ensure the names of respondents be reflected in the court list.
Obliged.
24.
Yes, Mr. Roderick. Yes.
This is regarding non-implementation of the order of this honorable court regarding payment of ADR revised payment. Up to Supreme Court, they contested the case with the, in that case also, Supreme Court also dismissed their case. Now, my lord, they are depriving me, my lord, regarding my dues, my lord. I have made last representation regarding this, but nothing has been done, my lord. Last order, your lordship, may kindly see page 37.
You've not filed any contempt.
Did not file, my lord.
Yes, what do you say?
Lordship, this is a bit complex, Lordship. If Lordship comes to page 18, Lordship, very small facts, Lordship. Page 18.
Yes.
Lordship, an order was passed in the year 2002 itself, Lordship. Therein, Lordship, the service of the petitioner was terminated and court directed, Lordship, if Lordship comes to page 19.
Hmm.
Page 20, Lordship.
Yes.
7th line, Lordship.
Yes.
But in the spirit thereof, considering the fact that the petitioner has rendered almost continuous service for 5 years in a particular capacity and of contract considered view, I am of the considered view that until the case of the petitioner for regularization is equitably considered by the state, he ought to be permitted to continue in service. If at any stage, any post of peon or any other post of grade 4 is required to be filled up in the consumer forum of the state and such posts are advertised, the petitioner must undergo the process of selection. It will also be open for the petitioner to participate in any selection process for any other grade 4 post that may be advertised in the meantime. If, however, any scheme is formulated for regularization of employee of the category of which the writ petitioner belongs, the case of the petitioner will have to be considered in accordance with such schemes. Until the petitioner qualifies himself for appointment on regular basis by any of the modes as indicated herein above, his present status will continue. See, he continued like that, Lordship. He himself never participated in any other selection process, nor any post was advertised by the consumer forum. Subsequently, Lordship, another writ petition was filed at page 21.
Yes.
Herein, Lordship, if Lordship comes to the operative portion, Lordship, that is at page 25. Down below, Lordship, serial number 4, paragraph number 4.
Hmm.
For the reason foregoing, this writ petition succeeds. The state respondents are directed to pay the petitioner the revised scale of pay with increments with effect from 1/1/1996. So this direction came for revised pay scale, Lordship. This was contested before the division bench as well to the Supreme Court also, which went against the state. Now the decision, now issue is, Lordship, whether his service to be continued. So far as the first judgment is is there, Lordship, he never participated in any regular process, Lordship, any regular process of selection. So authority forwarded the file for opinion to the Advocate General, Lordship. In the meantime, to my knowledge, Lordship, he has already given the opinion, Lordship. So authority will take a decision very soon, Lordship, in this issue.
But after the judgment of the court, whether Advocate General can withhold
No, two issues are there, Lordship. His continuation has not yet been decided.
Which judgment was upheld or by the
Second judgment.
Second judgment.
Second judgment.
so second judgment, what was the final direction?
Second judgment, Lordship,
regarding
if,
payment of area revised payment.
Lordship, if Lordship comes to the page 25, Lordship, one line, Lordship, I would like to show.
Hmm.
Lordship, this is the 11th line from the bottom, Lordship,
Hmm.
page 25. It is thus quite logical and reasonable that he has earned at least the right to be paid the revised scale of pay for the post of peon in accordance with Assam Services Revision of Payrolls 1996. So issue was only whether revision is to be paid, revised pay is to be given or not.
Already
No
it has
issue,
been-
no issue of
what is
regularization.
submission, Lordship?
No
What
issue of
submission has been
regularization.
made, interpreting the judgment of this honorable court.
I'm not
They're
interpreting.
taking advantage of that. I did not.
I'm
find
not
them.
interpreting.
Now interpretation is going on regarding this.
I'm not interpreting, Lordship. In the first case,
This is
his
not fair.
service was
This
terminated.
is not fair.
No, but paragraph 4,
Yes, ma'am.
direction is to pay the revised scale of pay with increments.
Yes, ma'am. From,
Because
because I am deprived of this, pay revision has been made for all employees, but since my
service is temporary, that is why.
So
that
what
is
is
why-
the
Definitely, we are going to comply. This is the order passed by the. up to the
If they
Supreme
take
Court,
any
Lordship,
action against
we
me,
have
then
to
it is
comply.
all right, my lord.
But
But how can they,
what-
how can they deprive me, my lord,
Lordship,
regarding my
what
case?
happens thereafter, whether he will continue or not, Lordship, that decision we have to take. We are waiting for that decision is to be
take those decisions, but
a different, Lordship. In the first judgment, issue was different. Second case, Lordship, issue was only relating to revised pay. And revised pay issue has been settled that we have to comply. And we will comply. But so far as the first issue is concerned, that decision has to be taken.
what decision?
Lordship, may kindly see the direction. A specific direction was passed. He was given the opportunity of participating any post advertised by the Consumer Forum itself or any other grade 4 post in any other department. Page 20, Lordship, from the middle portion, but it is, but in the spirit considering the.
What is this letter 30, notification 3010, 2001?
Which page, Lordship?
There is some notification referred to
Yes,
in page number
20. This is a government notification, my lord, I have not annexed it. Because my case is regarding payment of arrears dues, my lord, not regarding the regularization. Even I am continuing, my lord, no offer has been made regarding any.
Lordship, if Lordship comes to
Post.
page 19, Lordship. Page 19, Lordship. The state government has issued a notification dated 30/10/2001, whereby pursuant to certain observations direction made by this court in WBC number so and so, the state government has taken a policy decision that master roll workers, workers, employees of the state appointed after 1/4/1993 and who have put in 5 years of continuous service as on 24/1/2021 would be allowed to continue in service. That is a scheme of the state government, Lordship, under the different departments, Lordship, not under Consumer Forum. So what I'm praying, Lordship, so far as the revised pay is concerned, that we have to pay. No option, the other option for the state government. But after that, Lordship, whether the petitioner will continue or not.
That is not the issue before in this petition, my lord. They may take any action against this judgment of this honorable court, my lord. If they can.
Your claim is only revised pay.
Yes, my
Yes,
lord.
Lord.
It is not
So
the
you
issue
pay it.
regarding regularization.
When
Lordship-
can you pay it?
Lordship, state government, the concerned department was waiting for the opinion to be given by
How
the.
long, my lord?
That has been already, I have, so far as my knowledge is concerned.
Opinion can't be the contrary to judgments of the
No,
court.
so far as the other issue is concerned.
So other issue you
Connected
take
issues
part.
that were there.
Other issue you take part.
Lordship, I am issuing
May-
this.
may I
order.
begin,
How much-
Decision will be taken very soon, Lord.
How much time is required?
Lordship will grant me 4 weeks time. In the meantime, a decision will
4
be
weeks
taken.
is too long.
Your lordship-
Otherwise also, this is his
Lordship may
entitlement.
dispose
Lordship.
of the matter with a
This
time
is his
period may
entitlement,
be given.
Lordship.
And
Otherwise also he will get the same order, Lordship will not pass it. This has been settled by the Supreme Court itself.
So if he's entitled, why don't you give him?
No, so only because of the connected issue, that is the first issue, Lord.
No, but these are two separate issues.
Yes, Lord.
Why are you connecting them? These are two separate issues.
That I admit, Lord. These are separate issues.
Then
But on that issue, Lordship, they are contemplating
on
to
that
take a
issue, let
decision.
them
Lordship.
take as much time as they want. There is no, he's come before the court seeking a direction for the revised pay, which has been upheld by the Supreme Court.
Yes, Lord.
Then
No, otherwise this direction has already been passed. This direction is already there. This is only a repetition of that same order, Lord. Lordship will pass the same order, nothing else, Lord. Because
why should we keep on passing the same order? Why should we
that is
not-
what I am asking, Lordship.
why should we
That
not
order
convert-
is already there.
So why should we not convert this into a contempt and ask you why you have not complied with this order?
The contempt, Lordship, it was an order of, if Lordship
Whatever
comes
it
to.
may be, go and appeal.
So at this stage, Lordship, I am only praying for some time.
Not
Lordship.
4 weeks. We can't give you 4 weeks to comply this order. Only ground that you're waiting for the opinion of the Advocate General. That is not.
No, that
proper.
has already gone, Lordship. It has.
It may have gone.
Yes, Lord.
The department cannot use the garb of waiting for opinion to comply with an order where no opinion or no clarification is sought.
I understand, but Lordship, as legal issues are concerned, Lordship, they also want to have some.
What legal
assistance from
issue?
them.
There is a direction of the court.
Yes, Lordship.
They have
Lordship,
not filed
at
an
this,
appeal, they have not filed
at
an
this
appeal.
stage, Lordship, I am only praying for 4 weeks time.
Not 4 weeks. We'll give you 2 weeks, you complete it. telling which will pass consequential.
Then Lordship will direct, within 2 weeks, Lordship will take a decision, Lord.
You are asking for time, we are giving you time.
Lord.
But we are refusing to give you time for 4 weeks in view of the clarity in the order itself.
Yes, Lord.
You are saying that to carry out this order, you require an opinion of the court, opinion of the Advocate General. Is it necessary here?
No, I'm repeating, Lordship, they being officers.
Connected issues you carry out. How the connected issue is to be, supposing you take a decision not to regularize him. But till the time he worked,
Yes,
you will have to give him the revised pay.
Lordship, I'm praying for 3 weeks' time, Lordship. We are going to take a decision on this issue. 3 weeks, Lordship.
Yes.
We are giving you time till 18th August. No further. 18th August, Mr. Chaudhary? Yes. Heard counsel for the parties. The petitioner is before the court, reiterating his earlier prayers, seeking a direction from the court for release of his revised pay for the period he is entitled. So, this issue was settled by an order, by judgment and order dated 8/2/2013 in WPC 4383 of 2004, and which ultimately came to the Supreme Court, and which ultimately came to be confirmed upon the Supreme Court dismissing the SLP filed by the state. Is it an SLP filed by the state?
Yes, Lord.
State. When was it filed?
The date I couldn't recollect, my lord.
All right, was filed with the state. In spite of that,
Same was
directions-
dismissed, my lord, 02/01/2019, in 2019.
2/1/2019. So, in spite of that, the revised pay has not been released, the writ petition. Being aggrieved, he has approached his court for a second time on the same issue. Where Mr. Nayak, learned additional AG appearing for the state, on the other hand, submits that in view of, it submits that there is another issue which is required to be decided in respect of the regularization sought for by the petitioner. Stop in this regard by judgment and order, by order dated 6/6/2002, the coordinate bench in CR 1675 of 1997 disposed of the writ petition, directing the respondent authorities to consider the case of the writ petitioner, directing the respondents to consider the case of the writ petitioner for regularization.
But this is not an issue in this.
And further holding that the petitioner must undergo the process of selection in view of any post of peon in grade 4, which may be required to be filled up in the consumer forums of the state, under which forum the writ petitioner is presently serving. Stop. Where Mr. Nayak submits that the department is awaiting for the opinion of the Advocate General of the state in view of the directions contained, in view of the issues relating to the writ petitioner towards his regularization. Stop. He, however, fairly submits that the question of pay of question of release of revised pay is already settled by the apex court. But in view of the opinion of the Advocate General of the state, which is being awaited by the respondent department, the revised pay amount to be released to the petitioner could not be undertaken. Stop para. From the pleadings available on record and upon hearing the submissions of the court, as well as upon careful examination of the order dated 6/6/2002, passed in CR 1675 of 97, as well as the judgment and order dated 8/2/2013, passed in WPC 4383 of 2004, which had attained finality upon dismissal of the SLP filed by the state by the order dated so and so. It appears to the court that both these issues are two separate issues, while the issue before the coordinate bench on 6/3 in CR 1675 of 97, which came to be disposed of on 6/6/2002, the question of regularization was the issue. Question of regularization of the writ petitioner was the issue. Whereas in WPC 4383 of 2004, disposed of on 8/2/2013, the issue was release of the revised pay to the petitioner, revised scale of pay to the petitioner in the post of peon. So both these issues may be connected to the writ petitioner, but the present writ petition has been filed by the petitioner in view of the inaction of the respondents in complying with the order dated 8/2/2013, passed in WPC 4383 of 2004. Stop. Under such circumstances, while this court permits the respondents to complete their instructions, it is made clear that where the directions of the court passed in WPC 4383 of 2004 attained finality upon the dismissal of the SLP filed by the state IT order dated so and so, the authorities are directed to release the revised pay of the writ petitioner in compliance of the directions of the court by the next date fixed.
That may be a bit difficult option. The authority will take a decision, but immediately it will be released as soon as possible.
What is difficult?
We are going to take it.
Huh?
By 18th doctor, we are going to complete the formality. But date of payment doctor, that may be like. Why? May not be possible because it's going to be a huge amount.
All right.
The next day doctor
We'll take final decision with regard to compliance of the directions contained in the order dated so and so, passed in WPC 4383 of so and so by the next date fixed. Stop. Let the matter be listed again on 18. Stop. Failure to comply with this direction may entail consequential orders from this court. Let's list accordingly.
apply.
Item 25.
May I please, Lord? Lordship, can you have a look on the order 23rd June 25, first order, then I'll.
May I please, on instruction received. Board decided to pay the rupees 25,000 per month, Lordship, as for the remaining balance amount this month.
Was it 23rd, 6/25 order may be looked at. 23 June, my lord.
23 June.
Yes, my lord.
$20,000, 2 lakhs on or before 15 July.
That's deposited months.
Deposited. Then
Next bottom, my lord.
such remaining dues of the petitioner hearing shall be paid to him within 3 months, 15 July, in terms of the schedule that would be prepared and placed before this court authorities by Nalbari Municipal Board by the next day. It is to be noted that the pensioner dues received by the petitioner quantified by the authorities Nalbari Municipal Board has been disputed by the learned counsel petitioner. This aspect of the matter shall be considered by this court at the time of final consideration. Now, my lord, 18 July 2025.
This order is very clear, Mr. Chakraborty, you have to release it within 3 months.
Yes, my lord. 25,000, my lord.
Lordship, they deposited a 2 lakhs amount, Lordship, and remaining balance amount, Lordship, they will pay the rupees 25,000 per month, Lordship.
Well, what happens to this order?
Yes, my lord.
Have you not communicated this order?
They've stated. I have already communicated.
You have communicated.
Lords.
Then,
Then
so
they received an instruction, Lords.
if they don't have money, how will they pay?
My lord, on their personal appearance on the before this court, this will be directed only 3 months, my lord. That is a specific direction made by this court, my lord. And prepare the schedule within the 3 months. That is the direction of this court.
18/7, Lords.
In their presence, my lord.
Honorable Court directed to place before this court schedule of payment, Lordship. Schedule for payment of remaining received pensionary dues of the petitioner, Lordship. That order has been communicated, Lordship, and after that I got that instruction, Lordship.
They were directed to appear, they appeared in court. Then how can they go back and give you this instruction?
I understand.
If you understand, then they're in contempt.
Yes, my lord.
They're in contempt.
Each time what will get that place instruction, Lordship. Who each time, Lordship?
You are the counsel, you have to explain to them that any undertaking given in court that too on special appearance, personal appearance.
I have already communicated, Lordship, by letter. There, Lordship. Each and every letter that I communicated.
You show us the fund position.
Lordship. On next day.
How will you show us? Through affidavit. We want the fund position to be duly certified by a chartered accountant, auditor, that this is the fund position as on the date of issuance of that report, and bring it on record. I heard Mr. Dekar, the counsel for the petitioner, Mr. Chakraborty appearing for the state. For all respondents. Mr. Dekar has pointed out to the court the order dated 23/6/2025 passed by coordinate bench, whereby the petitioners and respondents were directed to release an amount of rupees 2 lakhs within 15th of July 2025, and the remaining dues of the petitioner within 3 months after 15th of July 2025. Where is the decision of the board? Today, when the matter is called up, Mr. Chakraborty has placed before the court a communication received from the Nalbari Municipal Board, duly signed by the chairperson as well as the executive officer, that because of their paucity of funds, the remaining amount, although they have deposited rupees 2 lakhs in terms of the direction of the court, the remaining amount of rupees 5,54,000 payable to the petitioner shall be paid at the rate of 25,000 per month without fail. So, this communication, according to the court, is contrary to the directions passed by the court on 23/6/2025, and no application has been filed seeking modification or recall of the directions passed by the court. Stop. The court therefore considers it appropriate to direct the government advocate to place before the court, place on record the decision taken by the board, on the basis of which the communication dated, but it doesn't contain a date.
Nonsense.
Contain a date. On, huh?
Sorry for that, Lordship, on behalf of the.
No, why are you apologizing?
Mention the date, Lordship. Then there's on mention.
Then why have you accepted this
Yes,
communication?
Mr. Lordship.
So once I received that instruction, Lordship.
Mr. Counsel, you are an officer of the court.
Lordship, I
You must
understand,
behave like
Lordship.
one.
Understand, Lordship, that-
No, you must first behave like one. You have to stop identifying yourself with the client.
Lordship.
You are an officer of the court. You have to behave like one. Why have you accepted this notification, these documents without any dates? That too through WhatsApp? We direct the government advocate to place before the court the decision stated to have been taken by the board, on the basis of which it was decided that balance amount of rupees 554,000 shall be paid at the rate of 25,000 per month, which is contrary to the directions contained in the order dated 23/6/2025. So, we also direct the government advocate to place on record the proper audited report showing the fund position of the Nalbari Municipal Board by the next date fixed. Let these instructions, let this information be placed before the court on 22nd of August. Stop. In the event this information as directed is not placed before the court by the next date fixed, court may consider passing consequential orders against the erring respondents. List on 22nd.
Yep, yep.
26.
Wait, Mr. Lordship. In this case, the petitioner's husband was working as UDA, Lordship. Then he was promoted to the post of head assistant in a vacant post, Lordship, in the year 2017. He was an employee of the DRDA, and thereafter the DRDA was merged with the Concert and Rural Development Department. So after the merger, his post, he was not given the post of head assistant, but some lower post was given to him. At that stage, he filed a case, WBC number 5725/17. In that case, Lordship, this honorable court directed the Pensionary department to give him to create a post of head assistant and accommodate the petitioner on that post. The order was passed on 15/11/2018. But thereafter, they did not comply with that order, and accordingly, the petitioner filed a contempt case. That is contempt petition number 759 of 2019. That petition is pending before his honorable court. during the pendency of that contempt petition, the petitioner of the contempt petition was expired on 17/1/2021. Since there are some financial matter involved, therefore, the wife of the petitioner was substituted in that case. And during the pendency of that contempt petition, this petition was filed. The prayer of this petition is it was amended later on, prayer portion.
Release the pecuniary benefits.
Yes, Lordship. And second prayer was for, since after 2017, the question of compassionate family pension has come. So the petitioner may be considered for compassionate family pension. Now, Lordship, that contempt petition is also relevant to be heard together, Lordship. So my prayer is that both the case may be taken up together, because they have filed a reply whereby they have stated that they were not aware of the death of the husband. And before that order was
Now
passed,
here, no response has been filed.
they have filed, Lordship.
You filed. No reply is required.
No reply is required.
Right. It is submitted by the council with the petition that a contempt petition, connected contempt petition is pending, being contempt case number
759 of 2019.
759
59
of
2019.
2019. Let both these matters be listed together after 1 week.
Lordship, in the contempt petition today, this morning, I made a mention for listing on 6th. So on that day, it may come. On 6th of August.
On 6th, all right. List on 6th. Okay, let's pray for.
Item 27.
No extra copy.
My lordship may see the last order, my lord, last two order, my lord.
She wanted some extra copies of the
My
petition.
lordship may, for that I'm responding, my lord. Lordship may see the last two orders, my lord. Kindly.
Ah. Yes.
My lord, they have taken a time, one after another, my lord.
No, but if you don't serve extra
No.
copies, how will they get it?
No, that was not distribution. I'm sorry, my lord. That was not distribution. But
No.
I'm sorry, my lord.
This is a method, Lordship, wherein the employee died in the year 1996. And Lordship, very recently, the daughter-in-law, Lordship, the
Huh?
sons and legal heirs are there. But the daughter-in-law applied for pension in respect of her deceased mother, who died in the year 1996. So already the authority has processed the file, Lordship. And as I am told today morning, Lordship, these are the final state, Lordship, because of what difficulty they are getting. First, Lordship, it's a file of 1996. So it has become difficult to obtain the status from different branches. That is one issue.
But why should the delay be for 96? Why the matter was kept
So
pending?
it is not because of the authority, Lordship. In fact, daughter-in-law is submitted for.
Now this is filed by whom? By the mother.
Daughter.
This is by the daughter-in-law. And anyone's name is there in the nomination.
Nominee, I'm the nominee, my lord.
See, somehow she obtained the nomination from the son. Son is also alive. So on last day, Lordship, in the, may I pray, Lordship, let this matter be disposed of, Lord. Directing the authority to dispose of the entire thing within a specified period, Lord.
But without knowing what is the stage and whose name is there in the nomination?
My lord, petitioner name, my lord.
And the wife of the deceased is not there.
Not here, my lord. Only survived by two sons and the petitioner
Ah.
presence. So other two sons has given NOC. For that regard, the authority also dispersed me in my name. It is not in dispute, but I'm not a nominee, my lord.
Lordship will find my names.
Then what do you want? What do you want now? The area.
The heir pension and other service benefits, my lord, that has not been paid. Except one amount, 19,000 something, which was leave salary, my lord.
Do you have the PPO? PPO is not issued yet. Nomination?
Nomination is not in favor of the petition. Annexure 7, my lord. That was the payment I received, my lord.
Is
Page
the
46.
nomination here somewhere? What is the name of your father-in-law?
Passport, my lord. Pradisi passport, my lord.
Hmm?
Pradisi passport.
Case 40 is the authorization given by the husband of the petitioner. He is the son of the deceased. That's all there is. Application In this matter, recently he filed one additional affidavit also. I'm not having that copy. Lots of comments not. In forward the same to now for some additional documents has been annexed.
No, that is already part of the copy.
Have you filed any additional affidavit?
Yes, my lord.
When?
That too, my lord, it is not on my record, but I have been in, I've made a communication from my clerk, my lord. already
It is not here also.
Here, annex documents dated 7/7/2025. So thereafter, what's the record?
Have you filed or you have not filed?
No, I was I have received instruction that we did file, my lord. But
Instruction
filing number I
from
don't have, that's the problem, my lord.
Mr. N.K. Madi, Lara, counsel for the petitioner, submits that an additional affidavit has been filed bringing on additional in records. The same, however, is not available in the case records. Registry to trace out the additional affidavit stated to have been filed, make necessary endorsements in the office note and connect it to the case report and list the matter after 2 weeks.
My lord, that may kindly be fixed.
After 2 weeks, the respondent will also obtain instructions on the matter. After 2 weeks,
That may, otherwise, sometimes, my lord, difficult to list.
2 weeks on a date to be fixed by the registry.
All right, my lord. Applies, my lord.
28.
Instructions are for my lord.
Yes. MSTS now for the respondents prays for further time to complete the instructions. Further 3 weeks time to complete the instructions.
Yes, and 2 days, yes.
29.
Let the matter be listed after 3 weeks.
Because earlier served.
And extra copies, if not already served, be served on the petition. Yes, on the respondents. Yes.
May it please your lordship. Lordship, this matter pertains to non-payment of compassionate family pension to the petitioner and her minor daughter, lordship.
Yes. Compassionate family pension.
Yes, lordship.
Have you applied under the provisions?
Yes, lordship, we have preferred application before the respondent number 5 commanded.
Where is that application?
Lordship, it's in page number
19.
Yes, lordship. Lordship, I have been requested to furnish a declaration from any court which states that I am the wife of the petitioner. But however, lordship, the petitioner number 3, who is the minor daughter, lordship, is the natural daughter of the husband of the petitioner who died in harness, lordship.
Is there any other wife?
Yes, lordship, as per our instruction, there is another lady lordship. So there are 2 wives lordship of the deceased.
2 wife or mother?
2 wives, lordship.
2 wives.
The lordship,
Visit our instruction we want to put on. Record.
2 wives.
Yes, lordship.
One more than 1 wife.
I am the second one, lordship.
All right. This matter be referred for mediation. We are referring it for mediation.
Lordship.
To be listed on Agor last mediations when receiving date to Saibele, that we should be back. Make it 22nd August.
They could not submit any documents also. Lord.
So let them see, let them appear before the mediation.
Much obliged.
Right.
22nd August.
Obliged.
Item 30.
Yes, the affidavit of the respondents is ready, filed by tomorrow.
Mr. A. Ganguly for the respondents submits that he filed the affidavit within 2 working days. Within this week.
Yes, tomorrow.
Within this week. Mr. R.K. Sharma appears for the writ petitioner. The respondent, the petitioner may file the joinder affidavit to the affidavit proposed to be filed with the petitioner. List again. After 3 weeks. 3 weeks?
If it is not inconvenient, a date may be fixed, Lordship.
On a date to be fixed by the registry after 3 weeks.
31.
How much time? 3 weeks.
Short date maybe, yes, because there is salary has stopped without any notice, nothing is there. And moreover, petitioner 2 is suffering for illness since
No.
2019.
3 weeks, 3 weeks.
Fix a date, Your Lordship.
3 weeks further time is prayed for by the standing council appearing for Karbi Anglo. MS RR Soikia appears for respondent number 3. Mr. S. Islam for the petitioner. List again.
Fix a date.
After 3 weeks, on a date to be fixed by the registry.
And fix a date, rather difficult to
On a date to be fixed by the registry after 3 weeks, immediately after 3 weeks. They'll fix a date.
32.
Oh, bless.
May it please your lordship. Your lordship may kindly pass over the matter for the time being, lordship.
Pass over.
Obliged, lordship.
Can it be Monday, but by that time, there's some instruction, it will be helpful, but because he is claiming promotion.
Their counterpart is already here. Both of you agree.
Can it be on Friday?
Not Friday. It has to be this Friday.
Or maybe on Wednesday, yes. That written instruction is evident, otherwise, telephonically, they have paid something to do. But I will.
All right, Friday.
Friday.
Based on Friday.
Yes, yes. The post file vacant in the December 2020. They have to
As
fill
prayed
it up.
for by the council for the finance,
More help.
health department.
They've taken so many days for filing affidavit.
Thus, the senior council assistant
Transportation of they have taken.
appears for the writ petition. Friday.
First August.
The detail.
33.
Here also I have received some telephonic instruction of it. Let this matter be taken up after 2 weeks, Lord, sir. I'll file my affidavit. I'll get the instruction.
Any objections? Council MSK Puljari prays for the petitioner, Mr. D. Upamanu for the respondent's state. He prays for further 2 weeks' time. Prayer made is not objected to. List after 2 weeks.
It may be given, lordship.
On a date to be fixed by the registry.
34.
May I plead your lordship? The petitioner before your lordship was appointed as a constable, your lordship, and he was terminated from his service while he was working as a probationary, your lordship. Your lordship, what happened? The appointment letter which was given to him stipulated certain conditions, and one of the condition was that a affidavit has to be submitted regarding his non-involvement in any criminal cases or unlawful activities. Your lordship, after during application for the post, your lordship, there was no such criteria for filing an affidavit. And he also he filed the application. He was the selection procedure was complete. Till then, there was no criminal case filed against him. After the selection process was complete, due to non-declaration of the result, there was a mass process by the candidates who have undergone the selection process. And through Facebook and other social media, the candidates they had arranged a mass rally in front of the police headquarters, and in that mass rally, the petitioner also participated, and they were arrested for shouting dharnas and slogans, and they were put behind the bars, and subsequently they were released. But during after that, the appointment letters were given. In the appointment letters were given to 36 of the candidates, and 2 were dropped for taking part in the procession. As the petitioner's petitioner got the appointment letter, he was under the impression that his name has been exonerated from the criminal case. So he was under the impression that no criminal case was pending against him. So he, on the date of filing the affidavit, he was under the impression that no criminal case was filed against him, because it was the duty of the employer, and it was also a clause in the advertisement that appointment will be subject to police verification. So he was under the impression it was a bona fide, it was his there was no malice on his part, Your Lordship. And on bona fide, he has submitted the affidavit that no criminal case was pending against him.
Where is that affidavit
Yes, Your
available
Lordship.
here?
Lordship, I have annexed it. Page 49, Your Lordship, Annexer 5. Annexer 5, para 5. I have not been convicted of any offense involving moral turpitude, and have not been dismissed from service by the union government or by a state government or any local autonomous body. He was under the impression that as among the 36 candidates who were selected, 30 selected in the selection process, 36 were given appointment letters. So as the name of the 2 candidates were dropped for taking part in that mass process, he was under the impression that he was exonerated from that criminal offense, and so he filed that affidavit on that impression. Moreover, Your Lordship, it was a tribal offense, Your Lordship, not involving any moral turpitude. And whether the employer can...
Where is the order of termination?
Termination is Annexer. Annexer 9, page 56, Your Lordship. Page 57. Oh, no. Or termination on Annexer 8, Your Lordship, page 55. Last line, in view of the above, as per rule 367 of BN, Pawan Bordoloi of APRO, presently posted as at West Kirby Anglong, Yam Harem, is hereby terminated from the existing post with immediate effect. Lordship knows there are various judgments of the apex court, Your Lordship, wherein it has been envisaged that when the offense involved is tribal in nature and does not involve any moral turpitude, such cases should be considered liberally by the employers, Your Lordship.
Before we conclude by getting to the lesson, let's give an opportunity to file our affidavit. Because we have not filed our affidavit. Fundamentally, Lordship, during the probation, one agreement came into this thing.
Very little flag marks, plastic.
That still not be involved in any kind of Lordship, criminal offense or any kind of this thing. After that, just after some time, she will receive a letter has reached us informing that the Polton Bazaar PS case has been instituted against her under this and this offense. So basically, Lordship, during the probation, this has happened. And we have explained everything in our correspondence, Lordship. So I may pray for the Lordship to file our affidavit at this place.
How much time do you require?
2 weeks time, Lordship, because everything is ready.
Yes, 2 weeks.
Plus.
Heard counsel for especially the respondents pray for 2 weeks time, file their affidavit, which the counsel for petitioner does not object to the prayer made. Let's start 2 weeks.
If a date can be fixed, Your Lordship.
On a date to be fixed by the registry.
Oblige, Your Lordship.
35.
May I plead, Your Lordship? Lordship, in this case, the arrear maintenance subsistence allowance of the petitioner has been withheld, Your Lordship, for his period of suspension.
Yes, yes.
It has been not released till now.
Why not release suspension? Please get instructions. Again, after 2 weeks on the prayer made. Matter will also be listed after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
36.
May please, your lordship.
Yes.
Lordship, the petition of your lordship is an employee under the established superintendent of police, Norway, lordship. One FIR has been lodged against him and subsequently he was removed from service. Thereafter, trial has been initiated and in that trial he was acquitted. Against an order, lordship, the state preferred an appeal and the appeal dismissed. And the petition of your lordship has also submitted several applications, are also preferred an appeal before the responding authority, but till now, lordship, no reply and no outcome of the appeal. And lordship, by order dated 2/6 and 11/6, this honorable court has, before issuing notice, has asked for seeking in instruction from the responding authority, lordship, but that could not be obtained.
So we have received some kind of instruction, lordship, they seem that petition reference already submitted in regard to lordship, regarding lives on
Let him file. List after 4 weeks.
Lordship,
Enabling
is short date,
the-
lordship, because the petition will be retiring from service on 34/26, lordship. Few months only left.
26.
April, lordship, few months left.
List after 3 weeks, enabling the government advocate to file complete instructions and file necessary affidavit.
And lordship, liberty, if required, I will find my reply.
With liberty to the petitioner to file rejoinder if so advised.
Obliged, lordship.
37.
Lordship, mirror pertains to promotion of the petitioner's lordship.
How much time? 3 weeks. Yes.
Yes, lordship.
Counsel for the parties have been heard. Mr. S. Pora, standing counsel, plays for 3 weeks' time to file his affidavit as it is submitted that the instructions have been received. List this matter. Prayer made is not objected to by the counsel for petitioner. List after 3 weeks on a date to be fixed by the registry.
Much obliged.
38.
Me. Lordship, here the petitioner is a Gaon Bura, my lord, and he has been working since 2010, my lord. And without any notice, without any inquiry, and without being heard, he has been removed, my lord. And there was an order of the Deputy Commissioner, my lord, respondent number 3. He has directed the respondent number 5, that is a circle officer, to make an inquiry and submit the report within 7 days. And that order was passed on 15/7/2024, my lord. But till today, nothing is there, my lord. And this person, he has worked relentlessly from 2010, my lord. And there was no blemish. There was
Where is the order of removal?
Lordship will kindly see page 43, my lord. Before that, if your lordship will kindly see page 42, annexure 6, ma'am. Annexure 6, page 42. That is the order of the DC, ma'am. Respondent number 3.
Annexure 6.
Yes, ma'am. Page 42.
Yes.
Thereafter, your lordship may kindly see annexure 7.
Where is the order of removal?
That is page 43, ma'am. So DC has passed this order. Thereafter, that person must remove. By order dated 15/7/2024, ma'am. And now we are in 2025, ma'am.
No, 43 is entrustment of.
That has been considered as a removal. Nothing is there other than this, madam.
Huh?
I have been removed by this order. That other person has been given the charge, and from that day, I have not been working as a Gaon Pradhan, my lord. And my honorarium, nothing has been paid, my lord. But this has been considered as a and I have filed an RTI also, my lord. And they said that nothing, inquiry is still going on. So we can.
Your appointment is pursuant to a selection.
Yes, your lordship may kindly see my appointment order. That is, this one. Annexure 1, my lord. Page 23.
Yes.
There is my appointment order. 16/2/2010. And if your lordship will kindly see the last order also, they were given the last chance, man. Order dated 23/6/2025 of this honorable court, man.
Yes, respondents.
The receipt of errors. Otherwise, with regards to the earlier order 23/6, whether he was moved or not, only one paragraph saying that temporary removal was on the allegation of misconduct and complaints issued to public, which has been confirmed by the inquiry officer, that is the circle of for revenue circle. The remuneration of the concerned Rao Pradhan has been kept in abeyance, since he was also temporarily asked to hand over the charge for his lot 2 of property, units Rao Pradhan and plot number 11. But it is silent with regards to whether he was temporarily permanently removed or temporarily removed. Again, I have to seek some instruction on the.
No, once you are appointed, you can't be removed like that.
After, in fact, an inquiry was conducted as per the terrorist comments which have been issued by. Inquiry was conducted, the petitioner was given opportunity of hearing, but the petitioner did not appear
Yes,
during the whole inquiry process.
as far as
And
my
he-
instruction goes, my lord.
In
Sure.
fact, admitted also, that the records also be called for, he admitted that.
And even the allegations is very big, your lordship.
Please let me.
Oh.
Also, during the inquiry process, he admitted, came later on, after the inquiry was concluded, as per the Ferrer's comments, it says that after the inquiry was completed, he came to the before the circle officer, he appeared there and said that he actually thought there will be backlash and he might be beaten up also. So to avoid that, he remained absent during the whole inquiry. So that is what the Ferrer's saying. Now, whether we were given opportunity of hearing or not, then the record will be, we can also, I have to seek a clarification. Whether.
Do it within 2 weeks. Heard counsel for the parties, the respondents claim that counsel for respondents submits that instruction is also received. Further instructions are necessary. Clarificatory instructions are necessary. Let these instructions be completed and affidavit, if any, if so advised, may be filed by the respondents within 2 weeks from today.
Date may be given, your lordship, otherwise it's very difficult to listen.
Why is it difficult?
I don't.
You
know,
make a
lordship.
mention, matter gets listed.
Lordship, sometime before matter also it doesn't get listed again.
18th August.
Obliged, lordship.
39.
Please, your lordship. Lordship, on the last date, the respondent had prayed for time to file the affidavit. It was supposed to be filed by the 18th of July.
They have received the signed affidavit, orders in to be filed by the authorities.
So
So total file.
file it today.
Meghalaya High Court order is already there whereby the criminal case has been quashed against the petitioner.
He's been
And
given
the-
liberty to file affidavit, let him file it. He has received it.
Lordship,
MSP
a date may be
Agrawal.
fixed. A date may be fixed, Lordship.
MSP Agrawal appears for the petitioner, Mr. CKS Burma. Government advocate submits that the affidavit can be filed. CDC. For CDC, the government advocate, no, CDC, the affidavit will be filed within the course of this week.
Yes.
Stock matter be listed thereafter. Would you be filing a rejoinder?
Lordship,
Perhaps.
we will have to receive it first.
The matter therefore be listed after 3 weeks. By which time the petitioners may also file rejoinder if so advised in the meantime. list on 22nd of August.
Due to oblige.
For admission with notice served, reply filed. Item 40.
Well, that was the case, my lord, where that dispute was, my lord, regarding date of birth, my lord.
Huh?
I was regarding date of birth 56 and 66. My lord, I was directed to bring, my lord, the copy of the my lord, original copy, my lord. You can give it.
PAN card.
Yes, my lord.
No, sorry, the PAN card, your date of birth is 28/7/66.
Yes, my lord.
Aadhaar?
Same.
Huh.
Tar ID.
So where is the difficulty?
In my service book, it is written as 56. In his birth certificate furnished by the petitioner, it is written as 56. In the regularization order, his date of retirement is written as 56.
Date of retirement.
Yes, I mean 2016.
Huh.
If it is 2016, then date of birth is 56, not 66.
Enquiry was done, kindly perusal, enquiry report.
They do.
Page 42. Affidavit filed by respondent number 3.
Yes, what is the report? What is the final?
Yes, my lord. The report
Decision.
says that, my lord, school certificate C. Bolenborough, where his date of birth has been recorded as 31/12/66, issued by the headmaster, Kayakushi Milon High School, 27/5/2020. PAN card of C. Bolenborough, his date of birth has been recorded on 31/12/66, issued by the Income Tax Department. Identity card of Bolenborough, where his date of birth has been recorded as on 31/12/66, issued by the Assistant Executive Engineer, PWD Patsara Rural Road Subdivision on 16/12/2005, and Assistant Executive Engineer, PWD TR Subdivision 16/6/2020. All these records appear to be clearly manipulated by the concerned dealing assistant Mohananda Sharma in connivance with chief petitioner Bolen Chandra Borough. This statement furnished by Bolenborough erstwhile MR Lebar has been fully examined along with all the relevant record in this record, as stated is in preceding paragraph. Sri Bolenborough appears to be equally guilty, although he has implicated Sri Mohananda Sharma in his entire episode leading to huge financial irregularities. It may be specifically mentioned that Sri Bolenborough was due to retire on 31/12/16 as per the records verified. I have carefully examined and considered the facts, relevant records, and circumstances of the matter. In my considered opinion, Mohananda Sharma is a prime facie held totally responsible for allowing Sri Bolenborough to continue up to July 2020, and thereby incurring unavoidable financial loss to the government exchequer to the tune of rupees.
Now, in your date of birth, in your service record, it is 56.
But, my lord, it is, my lord, at the time of regulation, possibly, my lord, it was furnished all 66, but it was wrong, my lord. 56 was wrong at the relevant point of time. It was corrected, and otherwise also, my lord, before.
When did you first file an application before the authority?
My lord, at the time of regulation, my lord, as it is evident from the record itself, my lord, because it is in the enquiry report, it is evident. The otherwise, my lord, certificate also along with me, my lord. In that certificate also, it is 66, my lord, school certificate. But subsequently, another certificate possibly, my lord, from somewhere it is collected by Mohananda Sharma, my lord. That's why possibly same date. That certificate, my lord, is doubtful, my lord. He is collected from somewhere. That's why my lord, censure is there also. Punishment has been already given to that person, my lord. Page 56, affidavit filed by the my lord, respondent number 3, an additional affidavit. Page 56. As per finding and report submitted by inquiry officer against DP case number 1/2020, Mahananda Sharma, junior assistant, is found guilty on the matter of overstayed period of service enjoyed by Sri Bolen Boro MR after his retirement. It is revealed due to negligence and careless duty done by dealing assistant Sri Mahananda Sharma, junior assistant, Bolen Boro, has been going to avail fresh undue advantage for overstayed period for service after his actual date of retirement. In view of the facts stated above, the undersigned signed by applying any judicious mind is hereby ordered to impose the penalty of censure under Rule 7(1) of Assam Services Disciplinary Appeal Rule 1964. He is severely cautioned not to repeat such a lapse in future. But in this respect, my lord, I want to place one judgment, my lord, to fully protect because notional my lord, benefit was given and earlier date of placing term is fully possibly covered, my lord.
In your case,
Both the dates were accepted. Allowed
your
to-
period of service got curtailed, according to you.
Yes, my lord. But my grievance at this stage, my lord, whatever may be the, my lord, date of birth, my lord, but he has been stopped to work, my lord, since long back, my lord, 2020 September onwards, he has been stopped to work, my lord. So, my lord, according to me, from that period, my lord, he may be allowed to draw his, my lord, retirement benefit, pensionary benefit, etc., my lord, and notional benefit may be given, my lord, because earlier occasion, my lord, rightly or wrongly, my somehow, my lord, I don't know what is the reason, my lord, behind it. No notice were served upon the, but he was also allowed, my lord. Somehow he was allowed after the 56 also, my lord, date. If it is calculated the date of birth 56, he is allowed to work more than 2-3 years. So, my lord, this type of recovery also may be stopped, my lord. Only fully protected by this judgment, my lord. Based on the Honorable Apex Court judgment, I have also placed here, my lord. That judgment also state.
What do you say, Mr. Nair?
So far as our records are concerned, if lordship comes to my affidavit lordship,
Hmm.
page 39, page 20. Page 38 lordship. Lordship, kindly see his date of birth.
Yes.
Page 31 where.
No, he's not disputing that.
Yes, I'm not.
He's saying that.
Lordship will kindly consider appreciate.
uh,
Till the date of his retirement, lordship, that is 2016, it remained as 56, lordship, it was never corrected. If it is not 56 and if it is really actually 66, then he should have approached the authority for correction of the service book also. That is what. Lordship, I kindly say next page 39.
What do you say about the judgment which he has pressed into service?
Notional benefit now.
No.
This Jagdish Kumar Deka.
We'll continue further hearing.
Yes.
In this case, lordship, another judgment is referred, lordship, that is Radhakishan. If lordship comes to paragraph 29.
Yes.
So that judgment covers my case, lord.
No, that is already, because, my lord, that is not covered. Because of, my lord, they allowed me, my lord. That was not my mistake, only more friend.
Paragraph, rule 95 lordship, of the pension rule.
We'll continue again on.
All these documents, lordship, PAN card, Aadhaar card, are subsequent to 2005 law. Initially, when this birth certificate was submitted.
These are accepted, na, in the time of regulation of service, 2005.
On 14th. List again on 14th.
Time being motion, item 56.
Yes.
May I please, your lordship? In this case, your lordship, the petitioner who participated in a selection process, your lordship.
He placed OMR seat.
OMR seat is placed, your lordship. That so far as my marks was, your lordship, shown to be 56, your lordship. We have raised two grievances here, your lordship. First, relating to OMR seat, your lordship, and secondly, in para 9 of my petition, your lordship, I have specifically averred that although they have issued a list, your lordship, calling the candidates for interview, your lordship, that list does not disclose, your lordship, whether how many persons from the ST planes has been called, or on general category, different categories, as on also, your lordship, what is your lordship, the cutoff mark for each of the categories, your lordship. The transparency requires, your lordship,
It's not mandatory that it has to be reflected.
No, your lordship will kindly see that percentage of marks is different, your lordship. That may not be reflected, your lordship. But how many candidates belonging to STP, your lordship? How many belonging to STS, your lordship? Hills, your lordship?
You belong to which category?
STP, your lordship.
STP.
Now, your lordship will find, your lordship, page 31 onwards, your lordship. This does not disclose, your lordship, who belongs to which roll number belongs to which category, your lordship. Page
You
30.
file RTI and ask how many are there.
But it is, your lordship, it is their duty to place in the very first place, your lordship, in the
in the
Show us
results
something-
itself, your lordship.
Show us something that it is their duty bound to do it.
Lordship, unless your lordship, they disclose your lordship that what,
You-
how many numbers of candidates they have called for the your lordship.
Show us from the advertisement or some rules that they're required to mandatorily disclose this.
It is normally done, your lordship.
Normally done.
Normally done,
But
your
it is
lordship.
not
For
done.
the sake of transparency, your lordship, it is done. your lordship.
Sake of transparency.
That is the, your lordship, ultimately public employment, your lordship.
That is
These-
okay, but you want these inputs, you get it from the department. There is a process for getting it.
No, that I will do, your lordship,
Ah.
but the
Court
ultimately,
cannot facilitate in building up your case.
no, your lordship, that's not my case at
You are
all,
aggrieved that you are not selected, which is quite understandable.
lordship.
But now, why you are not selected, whether anybody else has been selected, all this.
No,
will
your
require
lordship
an
will
inquiry.
kindly see that, your lordship, at the end of the day, your lordship, my non-selection or selection is not the issue, your lordship, right now. The case is, your lordship, unless they come up with something.
Show
Now,
us-
tomorrow, your lordship,
Show us from some provision of law, rules, regulations, that it is mandatory. It has to be shown from some.
now your lordship will kindly see, they have, your lordship, in the advertisement itself, they have said, your lordship, that how many posts are reserved for the STP, how many posts are reserved for the STH,
Right.
how, in the advertisement itself, your lordship. Now, once you categorize them, your lordship, in the advertisement, then while calling people for the Viva post, your lordship, you will not show the category, your lordship, in which how many candidates are
Was
called.
there any written?
Yes, your lordship, written, your lordship, after written, your lordship, this was done, your lordship. Now, your lordship will kindly see the advertisement at page 19 and page 20. Very categorically, your lordship, how many posts are reserved for unreserved SC, STP, STH.
No, you can't have a grievance merely because these selection in respect of these categories are not disclosed. Your grievance will be that although you should have been included in this category, somebody else was included, or the marking pattern or allocation of marks is incorrect. Except otherwise, that the advertisement or the rules or the notifications mandatorily disclose, mandatorily require that all these information must be displayed in the notice board or public.
Lords. That is not there in the
Ah.
advertisement.
So
But your lordship, it is in normally in all.
you
all-
are entitled to go and inquire and
No,
find
no,
out.
that your lordship, I will do, your lordship. That's, but the point is, your lordship, by the time your lordship, 30 days time is over, your lordship.
What is your ground for challenge now?
Now, the ground for challenge is this, your lordship, that they have not come. Now they are saying, your lordship, I am 56.
No.
Now, they should have disclosed what is the cutoff mark for ST, your lordship. Tomorrow, your lordship, third party right will be accrued by the time I get an information under RTI, your lordship.
No, but
Problem with these laws are this, your lordship, RTI.
third party right will see, supposing you are entitled to be selected, you have been wrongly selected, maybe third party right will accrue, you may have to issue notice, etc.
Lordship.
But if it can be, if you can make out a case that you have been wrongly ousted, the court will pass appropriate orders.
That is there, your lordship. But to relegate the individual candidates to such steps, your lordship, they could have, your lordship, clearly spelled out in this
All
advertisement.
right, let us say that many number of candidates are selected in STP category.
Lordship.
How does it benefit you? You are not selected.
No, that is not the case, your lordship. Then I could have, your lordship, I could have.
Then your prayer before the court will be, no, why the marks, individual marks have not been disclosed.
No, that individual, that cannot be, your lordship. To that extent, that will be too far-fetched to claim so far as the petitioner is concerned. I will not make that.
How does it develop? How does it build up? How do you have an accrued right that the total selected candidates have not been disclosed, therefore you're deprived?
No, your lordship, no, my point is, your lordship, when you have categorized the candidates, your lordship, these are the posts reserved for STs, then your lordship, it is your duty.
All right, let us accept your submission
Lordship.
that it is their duty, they have not done so.
Lordship,
we direct them to do so.
Lordship.
How do you make out a case that notwithstanding this information, or from this information, it is clear that you ought to have been included, but you are not?
Lordship, that, your lordship, that once they disclose that, only then I can have a case, your lordship. Otherwise,
So that-
I cannot have, your lordship.
So
That's why, your lordship,
that you know the facilities are the available.
No, no,
manner
I
in
know,
which
your
you can
lordship.
gather.
Problem is, your lordship, is that these are time taking, painstaking, your lordship,
do not
going to the extent
mind-
of
We do not mind passing such orders, but it will
Lordship.
become the order of the day.
lordship.
Anyone and everyone who is unsuccessful will come before the court, demand that call for record, show me the marks.
What has fallen from your lordship? I agree, your lordship, but they could have, your lordship, for the sake of transparency, it was on their incumbent upon them to, your lordship, that once they disclose that everything ends, cut off mark, and normally what they did, your lordship, APS and
Yes,
others.
Mr. Solia.
They have not even approached lordship or representation could have been filed, which would
Okay.
be considered lordship.
That I have filed.
Well, not lordship.
Can you show them the cutoff marks for this category STP?
The lordship grants us some time, we can provide them the.
Lordship,
They've never approached the right authority, lordship.
But we are not passing an order.
lordship.
It is the magnanimity of the respondent counsel that he has offered to give it to you, but not under our orders of this court. Our learned counsel for the party. That will be deferred to be listed again after 4 weeks.
After 2 weeks, your lordship. Just that.
2 weeks, all right, 2 weeks on a date to be fixed by the registry, enabling Mr. A. Choliha, learned standing counsel, Health Department, to complete his instructions.
Shall place it in court.
Place it in court, yes.
Deeply obliged.
Timing 22.
May I have your word? Lordship, I have served copy.
Yes, sir.
Lordship. He is required, lordship, to implead, lordship.
Heard learned counsel for the parties, this IA has been filed for impleadment of the opposite party, Sri so-and-so, as a party respondent in the accompanying contempt case number 695 of 2022. So this contempt case has been filed alleging willful disobedience of the directions contained in the order dated so-and-so 5/4/2022, order dated 5/4, judgment and order dated 5/4/2022, passed in WPC 177 of 2015. It is submitted that the therefore, during the pendency of the contempt petition, the opposite party has been appointed as the Principal Secretary, Government of Assam, Pension and Public Grievance Department. The earlier incumbent, who was arrayed as party respondent number one, has demitted her office, and accordingly, the learned counsel for the applicant submits that the opposite party, being a necessary party, is required to be pleaded as party respondent in the accompanying contempt petition number so-and-so, as the directions contained in the order dated so-and-so, passed in WPC so-and-so, has remained not complied with till date. So there are Mr. D. Nath, learned
For respondent number 5.
counsel appears for respondent number
5.
5. And who is for respondent 1?
One not appear till then, lordship.
Mr. S. Doctor appears for respondent number 2 and 3.
Only 2.
Only 2. None appears for the other respondents. Para, having heard counsel for the applicant and considering the prayer made in the application, since the opposite party, since it is submitted that the opposite party has been added, has assumed office of
Commissioner and Secretary, Lord. Presently, the post is Commissioner and Secretary.
Principal Secretary has been changed to
Lord,
Commissioner.
Commissioner said.
Was it earlier known as Principal Secretary?
Yes, Lord.
You assume the office of Principal Secretary, Government of Assam, Pension and Public Grievance Department, School Guwahati, which has now been re-nomenclatured as Commissioner and Secretary, Government of Assam, Department of Pension and Public Grievance. Stop. Court is of the view that the opposite party is a necessary party as the directions contained in the order dated so and so.
The order paragraph 30, Lordship. Page 34, Lord. Relevant direction is there.
As in terms of the directions contained in the order dated so and so, passed in WPC so and so, respondents were directed to issue declaration in terms of proviso to Rule 31 of Pension Rules 1961 that number 2 render the service of the petitioner from so and so to so and so, page 34, 35, side number, to qualify for payment of proportionate pension. Stop. This direction having not been complied with.
Contempt number 1.
Recovery was made.
No.
This direction having not been complied with, the contempt petition has been filed. It is also seen that a subsequent that the further direction not to recover rupees 48,069 has been complied with. So accordingly, opposite party, namely so and so, is arrayed as party respondent number 9 in contempt petition number so and so. I accordingly stands allowed disposed of amended course title to be filed within period of 1 week from today. Next, in contempt petition, you write, in view of the order passed in contempt petition numbers, in IA number so and so, view of the order dated so and so, passed in IA number so and so, opposite party in the IA, namely so and so, is arrayed as party respondent number 9 in the present contempt petition, contempt case. Stop. Era, issue notice on the newly imputed respondent, returnable 4 weeks. Steps by registered post AD, as well as usual course within 1 week from today. At least after returnable date. Mr. D. Nath and Mr. S. Dotto appearing for respondent number 2 and 5. You filed your is permitted further time to file their affidavit if so advised in the meantime.
Item 42.
I am opening on behalf of J.K. Goswami, standing on an apex line. Due to his medical emergency, and also regarding the private respondent has also filed affidavit in opposition to the
You are appearing?
The affidavit in opposition, Lordship. We need time to file affidavit in reply.
MS so and so appears for the petitioner, Justice so and so on behalf of the respondent. Is it the bank?
Bank, yes.
Respondent bank. Also makes a similar prayer that since a copy of the affidavit has been filed by whom?
14 and 16 to 21. Except 15.
On behalf of some of the private respondents, he requires further time to complete his instructions. The counsel for the petitioner also prays for accommodation for filing. Also renews the prayer, also prays for filing of rejoinder affidavit to the affidavit in opposition filed by the private respondents. List after 4 weeks.
43, 44.
Yes.
Please, Your Lordship. My lord, item 43 is in respect of a head pharmacist who is a loan candidate, and in the meantime, my lord, on 31st January 2025, he retired from service. But he will get his benefit, if Your Lordship. And the other case is in respect of the pharmacists. They are there in service. My lord, over here, the matter is in the year 2014, Pharmacy Council of India, my lord, introduced Bachelor of Pharmacy Practice Regulation, where earlier, as Your Lordship is aware, that all these pharmacy diploma holders are the pharmacists. Over here, in the 2014, the degree holders scheme came in. And as such, my lord, these petitioners before my lord, they have completed the course. And after completion, my lord, the fixation of pay scale and grade pay in respect of the head pharmacist.
All right, pleadings complete.
Pleadings complete. Only one thing, Your Lordship, is if I show only 2 documents, my lord, from their pleadings. Over here,
Who is appearing for the health?
my lord, health and finance, both of them filed their affidavit.
All right, heard counsel for parties, it is submitted that the pleadings are completed in the matter. The list, we list it for hearing.
My lord,
Will issue rule?
let it be admission hearing. Small matter. One person has already retired. Some others
Matter
are
be
part of-
listed for admission hearing on 19th August.
Yes, ma'am.
45.
Deeply obliged.
Your Lordship, may I please pass over this matter for the time being.
No time being, let it come some other day. On the request made by the counsel for the petitioner, matter stands deferred. Passed over for the day. Mr. Ardhor appears for the respondent.
46, 47.
My lord, 46, my lord, the de novo proceeding, my lord, what happened? Once, my lord, inquiry was started, my lord. Inquiry officer inquired the matter, found that, my lord, nothing is against the petitioner. So second time, my lord, on the basis of the criminal records, my lord, they initiate another proceeding. That has been stayed. Now the second 47 may be seen, my lord, that what happened, my lord, during the pendency of this proceeding, the petitioner left. Petitioner retired, my lord. Petitioner retired. Petitioner retired on 36/24. So the disciplinary proceeding left, my lord. My lord, because just your lordship. Huh? Huh? Oh. So, since the petitioner was not under suspension, my lord, the proceeding lapse. Paragraph 6 and 7.
Paragraph
6 and 7. 7 mainly, in view of absence or any provision of aforesaid regulation, it must be held that corporation has no legal authority to make any taxation of the retired benefits of the appellant. There is no provision for conducting disciplinary inquiry after retirement of the appellant, and nor any provision in that in case of misconduct established, taxation could be made from the retired benefit. Once the appellant has retired from service, so there was no authority vested in the corporation for continuing the inquiry even
for the purpose of imposing reduction the child benefits payable. to appellant.
He belongs to which department?
My lord,
Which state department?
yes.
What does the rule say?
If the, before doing the promotion matter, your lordship, they kindly pick up the item number 47. It's regarding disciplinary procedure. So what happens, your lordship, what happens, your lordship, trap case was registered, your lordship, you are
No, these details we are not asking. We're asking you that in the event of retirement,
yes, sir.
what is to be done with the proceedings which have been initiated? Does it automatically get?
It will be converted to proceeding under Rule 21 of the Assam Pension Act.
Pension and Assam services.
Some pension services pension Rule 21. Yes.
That too, whether de novo can be done or not. That is the main question, madam. Because here, once the inquiry was held, nothing was found against the petitioner.
Okay. You want to examine whether it is de novo or it is further inquiry.
"21 is where you are found guilty of grave misconduct, for which the proceeding has to conclude.
Your lordship may review.
Hmm.
The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government. If in a departmental or judicial proceeding, the petitioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after retirement, provided that a such departmental proceeding, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall after the final retirement of the officer be deemed to be proceeding under this rule and shall be continued or concluded by the authority by which it was commenced in the same manner as if the officer had continued in service. So here, your lordship, during his service period, disciplinary proceeding was initiated. And your lordship, it is not that it is a de novo inquiry. It was remitted.
No. De novo or fresh or further is the different issue. Mr. Saiwala, in this matter, it is about your challenging that after retirement, no proceeding is maintainable. Is that what your submission is?
My lord, that is one. And secondly, my lord, what happened, my lord? The criminal, my lord, because the first, my lord, the inquiry was held, my lord, nothing was found. Now, on the basis of the criminal proceeding, my lord, there are various judgments, my lord, that on the basis of the criminal, my lord, matter, when criminal case is pending, no inquiry can be held, my lord.
Right, then we'll keep it for a hearing day. We'll require some hearing.
My lord.
Heard counsel for the parties, it is submitted that pleadings are completed. The matter can be heard. Let the matter be heard. Matter be listed for admission hearing in on 26 August.
Okay.
48.
My lord, in this matter also the pension is withheld, my lord. The allegation was that there was a viral video in a social media regarding a lot Mondal accepting some amount of bribery in the revenue circle office. The petitioner was a senior assistant in the circle office, my lord. And he was arrested and he was suspended from service. Subsequently, this honorable court, my lord, order for reinstatement. Accordingly, he reinstated, and thereafter on 31/1/2023, he is retired, my lord. But till date, no pension is, my lord, paid to him, my lord. No departmental proceeding is started against him, my lord. So only a my lord, only a letter for hearing was issued, my lord, page number 21. Page number, my lord, page number 19, my lord. The circle officer had once issued only a letter for hearing, and there is no proceeding started, my lord, as per section 9 of the, my lord, departmental proceeding, my lord. And for the last 2.5 years, the petitioner, my lord, is without any pension, well, even provisional pension is not provided. And my lord, he has served
Who's for the respondent?
38 years. GAD department, my lord.
Where is GAD? Yes, where is GAD?
An affidavit was filed by the ADC, my lord, on behalf of department, deputy commissioner, my lord. And in the affidavit, my lord, one letter was annexed, my lord, where it is mentioned that the DCRG can be withheld, my lord, in the page number 49. But there is no provision for withholding the pension, my lord. Page number 49 of their affidavit, my lord.
Lordship, first we need to get the status of the criminal case, Lordship.
In the affidavit, when it is mentioned that it is in the investigation stage, my lord. Page number 45, my lord. Page number 45 in the affidavit, my lord. Third paragraph, my lord. Third paragraph, my lord. It is stated that the Government of Assam Revenue and DM Department dispute requested to the Special Director General Vigilance Anti-Corruption Assam to take the investigation by letter number so and so. The investigation has been initiated by the Director General of Police Vigilance Corruption Assam and is under process. In next paragraph, my lord, paragraph number 5, with regard to so and so, the writ petitioner, the deponent stated that as per notification dated 21/6/12, Government of Assam Pension and Public Grievance, the retired government employee against whom any departmental or judicial proceeding is continued, no DCRG shall be paid to him. This is gratuity, that come retirement gratuity, until the conclusion of such proceeding and the issue of the final order thereon. The proposal for final pension is pending at DDO level, and the final proposal will be submitted to the pension sanctioning authority after outcome of the criminal case. There is no provision, my lord. Only DCRG, my lord. And now, my lord, may I read the notification, my lord, based on which
What is your grievance here?
My grievance is that, my lord, no departmental proceeding started, my lord. And without starting any departmental proceeding, my lord, the pension and pensionary benefit is withheld, my lord, for the last 2.5 years, my lord. How can a government family survive, my lord, with his family members, my lord, for the last 2.5 years?
Where have you stated that in your writ petition? Where is that averment?
My lord, page number 4. Page number 4, my lord, last my lord, sentence I have mentioned with the circle officer, Daboka Revenue Circle by letter dated 2/9/22 had asked the petitioner to attend his office for hearing on 5/9/22. Petitioner had accordingly appeared, but till date, the result of the hearing has not been informed to the petitioner. Only a hearing was held, my lord, and till date, nothing is intimated to the petitioner, my lord. And at that stage, it is pending, my lord. The petitioner had approached the respondent authority to release it. Nothing is there. I have annexed the, my lord, the letter, my lord, hearing letter, page number 19, my lord. It is the only letter, my lord, regarding the, my lord, allegations, my lord. At this stage,
Where is his application, lordship, regarding this? Because he also have to submit the papers and all this, lordship, for processing the pension. This is required, but nowhere it is mentioned, lordship, that they have submitted the application.
Yes, my lord.
Requesting for a release of all the pensionary benefits and including the pension, regular pension, lordship. There is no any these things, lordship.
My lord, paragraph number 3, my lord, I have mentioned, my lord, that a petitioner submitted an application on 17/5/24 to the respondent for taking necessary action, official arrangement for retirement pension through online process on the advice of the respondent authority. Accordingly, petitioner's online common nomination form for arrear pension and communication pension had been filed on 8/7/24, my lord, in the head office district commissioner Huzai, and submitted all the documents, my lord, of the petitioner as per requirement pension form, but they did not take any action. Is there, my lord?
We have an updated instruction, lordship, when it is we have been instructed that no application has been submitted, lordship.
There is not.
No, you see para 5 of the affidavit.
Yes, lordship.
Last line,
Yes, lordship. Paragraph 5, this is the notification, lordship, where
last line of the paragraph.
the proposal for final pension is finding at DDO level and the final proposal will be submitted to the pension transferring authority after outcome of criminal case. This is for final pension, lordship, regular pension.
So, under what authority? It is only the governor who can withhold. And this has to be, that too, if there is any departmental proceedings.
Lordship, then kindly post it on Friday or on Monday, lordship. I shall get this thing, lordship. Instruction on that particular point.
My lord, the matter may be fixed on a hearing day, my lord, because my pension matter last 2.5 years is without any amount he is. It's very hard for his part to survive, my lord, without any money after.
Matter be listed on 12th.
On a hearing day, my lord.
12th August.
All right.
For admission hearing. Meanwhile, the state respondents will obtain up-to-date instructions as to the status of the pension proposal. Status of the status of the pension proposal submitted on behalf of the petitioner.
But one thing, lordship, during suspension period, lordship, the person has retired. Yes.
It is also stated in the bar that during the period of suspension, the petitioner had retired, and therefore the petitioner claims that his pension cannot be withheld. Yes.
My lord, the suspension is subsequently reinstated, my lord, with effect from the date of suspension, my lord, is on record, my lord.
All right. But you have superannuated.
Yes, sir. And my lord, one sentence may be added, my lord. On the next day, my lord, an endeavor may be made, my lord, to dispose of the petition, my lord,
An endeavor shall be made to dispose of the petition
Of life.
for the next day. Fix.
of life.
No, we can't take guarantee of that. You note down in your diary when the matters are fixed. Or you take a note now. It's fixed on 12. Even if your names are not there, please ensure that you appear before the matter if you want to. Names need not be reflected. It may be missed out. Why are you blaming the registry for that?
Other departments, the names are
If you don't appear, you don't appear. To say that your name is not reflected, therefore you did not appear, is a choice you make. Doesn't give you any benefit. This is only for convenience. Huh? What is the item number? 48.
48.
It is shown to be fixed. It did not just come like that. It was fixed.
Fixed item, my lord.
You check up the earlier order.
Yes, my lord, that is fixed, my lord.
Check up the earlier order. You have no time to look into the order sheets. We have made it available in the web portal so that you can have the benefit of going through the orders, but you don't do. Then how your name not being reflected is a ground for not appearing because the matter is fixed. It can't be fixed without an order. Yes, Mr. Fugan? We cannot guarantee that all names will be reflected in the cause list. Have a date. Yes.
Obliged.
Item 49.
Well, here
Itu lagi.
even after completion of 7 years, the family pension is not received. Well, her husband died in way back in 18.
Why not?
2018, my lord.
Why not granted?
Well, in fact, my lord, here the private responses are there. The daughter in mother-in-law. My lord, in fact, my lord, pension rule is very specific.
Why don't
Rule 143
Why don't
specific is entitled to only the wife.
Hmm.
So at this
Who are you? You are the wife.
my lord,
Hmm.
at this stage, my humble prayer for lordships,
Hmm.
it is difficult for me to run the family, my lord. In fact, my lord, can it be, my lord, interim measure of the interim prayer, your lordships may, since they are delaying the matter, they could not file the affidavit since long. My lord, the government has filed their.
Who is the petitioner? Who is the petitioner?
Petitioner is the wife of the
Wife.
deceased husband, my lord.
And private respondent
Are the,
456.
married daughter and mother-in-law, my lord.
Oh. Married daughter is not entitled.
No, not another. Rule 143 is very specific.
Ah.
Well, it says that pension cannot be divided among others, my lord.
Yes,
It's
you are
entitled to only the.
representing whom?
I'm for a private school, my lord, today and second appearance, not that you file.
Oh, we are not asking you how many appearances you have put in. Who, on whose behalf are you appearing?
4, 5, and 6, my lord.
4, 5, and 6. So 5 and 6 is not entitled to
No,
pension.
no, my lord, there is another case, my lord, in this case, my lord, this case is fixed on 21/8/2025.
It is altogether different.
This is a part of
They approach the my lord, succession certificate. It is difficult, my lord. My lord, there is a pensionary benefit, my lord. I am claiming for pensionary benefit. Rule 143 is very specific.
Lordship,
Or it cannot be the whole.
The second day, your lordship, I need to file an affidavit in this case, your lordship. I have a right, your lordship. I have prepared, your lordship. The person could not come down, your lordship. I need 1 week time, your lordship. In the meanwhile, I will file, and in the fact, your lordship, I will bring on record, your lordship, that the benefits he is seeking, your lordship. Now is, your lordship, a succession certificate in respect of that which has been issued, which is put under challenge, your lordship. And that is matter is part heard, your lordship, fixed on 21st of August, your lordship.
No, who are you?
Lordship, in this case, your lordship, succession certificate is issued in respect of all mother and 2 daughters, your lordship,
Pensionary benefits.
including family pension, your
So
lordship.
there is an order by this court that it is not applicable.
Lordship,
for pension.
I know, your lordship, that the status, at the end of the day, your lordship, in the before the.
No, see, pensionary benefits will go as per the pension rules.
Lordship, that's family
So,
pension, your lordship.
Family benefit.
Family pension.
family pension is granted on the basis of status, Your Lordship. I have fairly submitted before that court also, Your Lordship, that family pension is wrongly included in that particular order passed by in the succession case, Your Lordship. I have fairly submitted, Your Lordship, but what I am praying today, Your Lordship, let me file an affidavit, because, Your Lordship, there is a general prayer that pensionary benefit, Your Lordship. It may include your leave encashment. It may include, Your Lordship. That is why, Your Lordship, I need to file an affidavit, Your Lordship. I am seeking 7 days time, Your Lordship, not more than that.
They're always entitled to get file the affidavit. I cannot object it, mother. My humble prayer before the petition, there is an interim prayer, mother. I am in a difficult position, my lord.
Because
I am praying for family pension, my lord. In the provisional family pension, compassionate family pension, and provisional family pension. I am claiming for that only, my lord.
Your Lordship, on the very
That,
first day,
wife is entitled.
on the ground that another case is pending, Your Lordship.
No. That apart, married daughters are not entitled to family pension.
Pension, Your Lordship, I have fairly submitted this.
That's right. So,
admitted that, Your Lordship.
agreed. So 5 and 6 are out of the
Lordship.
claim,
Lordship.
which remains only 4.
Lordship.
4 also, the preference would be on the wife.
My lord.
He
In
has
fact, my lord,
waited
rule
for
is
your
very specific.
response.
It's only to wife.
What, Your Lordship, if I file an affidavit in opposition, thereafter Your Lordship will dispose of the matter. I don't have anything, Your Lordship.
No, you file. We are not stopping you
Lordship,
from
that's
filing it. We are trying to understand it.
Lordship, I have admitted, Your Lordship,
Ah.
that so far as family pension is concerned, it has been wrongly included. But, Your Lordship, rightly or wrongly, it is included in an order passed by a competent court, Your Lordship. If Your Lordship passes an order, will it not be contradictory to that order, Your Lordship?
Which order? Passed by whom?
Passed by Your Lordship, the learned district judge, Your Lordship, in my succession case, Your Lordship.
But that is contrary to the law.
That is why, Your
Ah.
Lordship, that will have to be overturned in a appropriate proceeding. And that proceeding is going on before the.
You are
before-
challenging a succession certificate in a writ court.
I am not. They are challenging, Your
Ah.
Lordship.
But the Supreme Court as well as this honorable court, very specific, my lord. Pensionary benefit
But
cannot be
any order
dividable among
passed-
other, my lord.
Any order passed by the court which is contrary to the statute, without the statute being examined or explained,
That will have to be ultimately, Your Lordship, overturned by an appropriate court.
no, but that doesn't mean that the person who's entitled will go without pension.
No, that is not my
So
case, Your Lordship.
then,
I am not
what
saying
is
that.
your, then we direct the respondents to examine the claim for provisional pension. Final pension will be settled.
Your Lordship can pass this order once, Your Lordship, on that ground, Your Lordship, coordinate bench, Your Lordship, rejected the interim.
We are
prayer, Your
asking you, how are you prejudiced?
Lordship. No, Your
5
Lordship,
and 6 is not entitled.
Your Lordship will kindly see. The word used this, Your Lordship, in the prayer, pensionary benefits.
We are asking her for provisional pension. That's
Lordship.
all. That's all. Are you suggesting that until this order is corrected, until this order of succession certificate is collected,
Lordship.
petitioner is not to be given any pension?
No,
You are also not
family
getting it.
pension. I am saying, Your Lordship, family pension. And in the.
That's
in
right.
the- And Your Lordship, so far as family pension is concerned, Your Lordship, there is no provision under pension rule to pay provisional pension. Provisional pension is paid to pay, Your Lordship. Employee once is retired till he gets, Your Lordship, regular pension.
That's right. But some benefit you'll have to give to the person.
Definitely, Your Lordship.
For what
he-
purpose?
What she is entitled.
She is
will
entitled
get.
to, under the rules, to get her family pension.
Lordship. that
Why
is-
is it been
I have
denied?
not objected. I have submitted even before the, Your Lordship, other court.
Who is
also.
for the department? Administrative department?
We have stated in our affidavit that due to this interstatutory fee, which is pending before this Honorable High Court, we are in a fix. We cannot actually discuss. So that is the only, because that has been.
What order is passed in the other matter?
That is, Your Lordship, part third, Your Lordship, will be taken up on 21st of August.
My lord, my humble prayer is again, my lord. My prayer for your lordships, that interim prayer to release amount of compassionate family pension. Well, compassionate family pension, my husband
Compassionate
died
family
during his
pension?
service, my lord.
tenure.
Wait. Compassionate family pension is under what rules?
In 2017, it is by way of notification, my lord.
Then is there a provision for interim
My lord,
release of
the
interim?
scheme of compassionate family pension, my understanding is that since my husband was died during his service, that in 2017, the government of Assam being it, my lord, by our office memorandum, that the unpaid, if he is my lord, retired in the year 60 years, the period unpaid salary, the family compensation by way of compensation family pension instead of compensation appointment can be disbursed to the malad family malad. That is why my prayer before this that interim prayer is that malad. But that is my entitlement. I am in a malad, difficult situation malad, almost 7 years without any income malad. Source of income. In the name of filing of affidavit, if the matter is dragging this way, I am in a difficult position, my lord.
2 days.
7 years.
Second day I am appearing.
No, let us hear the government on this.
As per rules, was provided and then that is the municipal effect. As per 143, one wife is the first beneficiary of any pension. Now, they have got this joint succession certificate from the Assistant Sessions Court. This has been challenged by the petitioner by filing of an interstatutory case is pending before your which has been stayed. Now, therefore, because of the stay order,
Who got the succession certificate?
Well, day before the succession case, I appeared before the district judge. A order has been passed that had been assailed by myself in the High Court and stayed the district judge order. And hearing is going on, as my learned friend has pointed out on 21st, it is next date is fixed for. It's a part heard matter for other bench. But I'm in a difficult position. That is why my humble prayer for assist, at least interim measures, some.
Your lordship may take it up on 7th, your lordship. On that day, your lordship, by that time, I will also file an affidavit and also bring your lordship that scheme, your lordship, before this honorable court. Your lordship will go through and if she is entitled, your lordship will pass. Only your lordship 6 days, your lordship.
Yes, Mr. Goswami.
As your lordship pleases, I pointed out my difficulty, my lord.
No, your difficulty is all right, but what is your interim prayer? Compassionate family pension.
My lord.
Under what provision?
Well, there's an OM, dated at present not with me. It is on 1/4/2017 onwards. The government of Assam.
You produce that OM at least.
Malad.
Heard counsel for parties. List again on. When did you say 7th?
7th.
Is 7th okay for you?
Malad.
7th of August. Enabling the counsel for the petitioner to place the office memorandum relating to compassionate family pension. Office memorandum, the government of Assam for grant of compassionate family pension. Meanwhile, counsel for respondent 456 will file their affidavit as prayed for. Mr. D. Bora appears for the state respondent. List accordingly.
Well,
7.
Mr. Bora may also, well, it is easier for him actually. I'll try.
I'll
51.
May please, your lordship.
Respondent lordship supposed to file their affidavit,
This
Hmm.
file lordship on 17/6 lordship.
but we have not received a copy lordship.
And without copy, how it can be filed?
That's can by the
You
department.
ask your,
It is here in the court.
But so we have not received a copy lordship.
Serve him one copy.
Can I?
Department can file their affidavit.
No,
No,
lordship,
department
it
can file
cannot be
every,
accepted
lordship.
lordship.
It's accepted lordship, it's a common practice lordship.
Contact.
Department lordship without serving a copy, they file it.
How can lordship?
I can give you 100 examples.
You may have, but we don't have. It is never.
But
accepted.
without service of
Lordship,
copies,
generally it's happened also.
huh?
I've found other cases also lordship. Without
You have a look here.
lordship, provide a copy also, no issue, and but we fix no issue.
There is no copy.
Yes, but we have not received a copy lordship.
You have to see lordship. You see, who is he? Who is he?
10% motion now. No, how about this? Lordship,
This
someone
number
has
is
received,
also there.
someone has received also, I'll pay extra copy lordship, but I have not received a copy.
Okay, who is our lord?
Lordship.
Give him a soft copy at least.
Lordship, yes, I'll take print out.
Matter
Sir.
to be listed after 1 week, by which date the affidavit, extra copy of the affidavits filed by the state shall be served on the counsel for the petition.
But we fix their lordship.
First, you go through it. You may like to file a reply.
Pensionary benefit lordship is wife is only lordship.
No,
so
but
yes.
you have not received the affidavit according to you.
Okay.
Yes.
Hearing item 52.
Obliged.
Yes.
May it please your Lord. In this case, we are challenging the termination of the petitioner's.
So first thing is that just there's one new thing I have noticed. These matters are being listed for hearing by mentioning. Matters are cannot be listed for hearing.
I don't know whether this matter was mentioned. Or
Yes, it is shown as by order for hearing.
But it was, in fact, if it would have been.
Your existing counsel must have made a
Maybe.
mention.
He is not here. I'll ask him.
See, this is the one. The mention memo has 3 columns, 3 options.
Okay.
Motion, admission and orders.
Mhm.
And by hand, they have included hearing.
Okay.
And had given a tick mark and the matter is listed, not just your fault, even the office is, perhaps they don't know how mentions are to be made. It is to be listed for orders, fix a date for hearing.
Yeah, that is true. And in fact, normally your lordship, matters are mentioned for hearing to be fixed on a hearing date normally.
No, that,
Normally.
that is,
But it has
that is
come
the
up on
different
a
issue.
motion day. That is one way, one thing.
Hmm.
I also was, I didn't know that it was mentioned or something, but anyways, your lordship. I'll ask him, he's.
What is your grievance here?
Basically, your lordship, the issue that your lordship will have to take care of, whether a person who has been released on, as provision, under the provision of Offenders Act, he has been terminated without a departmental inquiry, just a show cause and termination. Whether that is.
He was, this person,
This person-
petitioner was working,
He was working, he's a 4th grade employee. He was working.
regular
as a
employee.
Chowkidar, yeah, regular employee of the department. Then what has happened? There was some I'm just giving a gist of the matter. The misappropriation was there of about 2,40,000 rupees. And then there was a FIR was made. Thereafter trial has begun. In the trial, in the trial court, he was convicted on that. He has in the meanwhile, he has returned that money of 2,40,000 odd. That was returned back. And ultimately conviction was there. He made an appeal before the session judge. In the appeal, the appellate court has ordered his release on provision, under the Provision of Offenders Act. Once is under section 3 and 4 of the Provision of Offenders Act. So after that, your lordship, he applied to the authorities concerned that I have already been released. And initially, your lordship, since he was arrested, he was suspended. Now what has happened, when he made an application, he was issued a show cause that, so since you have been convicted, therefore you, you are show cause to reply. Then he filed his reply. After his reply, he was directly terminated without following the procedure of law. So basically that is the case. Now whether
once a person has been convicted, or sorry, once the person has been released on probation under the Provision of Offenders Act, there is a section 12, where it, yes, there's a section called section 12. We have in fact quoted that here, but section 12 is, once there is a, under section 12, it states, Lordship, Asani, Provision of Offenders. Provision of Offenders Act, your Lordship will kindly see section 12. I'll come to the other sections later. It কি mention করেছিলাম কি matter? Hearing or can I mention? কিন্তু hearing भी लिखा सब लिखो support. Anyways, your Lordship, 12. Removal of disqualification attaching to conviction. Notwithstanding anything contained in any other law, a person found guilty of an offence and dealt with under the provisions of section 3 or 4 shall not suffer disqualification, if any, attaching to a conviction of an offence under such law, provided that nothing in this section shall apply to a person who, after his release under section 4, is subsequently sentenced for the original offence. Now here, your Lordship, 3 and 4, your Lordship will kindly take up 3 and 4 section. So here disqualification will not be there in his service. So in that, let us come to 3 and 4. 3, power of court to release certain offenders after admonition, and 4 is power of court to release certain offenders on probation of good conduct. Here in this case, it is 4, not 3, it is 4. So I'll read 4. When any person is found guilty of having committed an offence not punishable with death or imprisonment for life, and the court by which the person is found guilty is of the opinion that, having regard to the circumstances of the case, including the nature of offence and the character of the offender, it is expedient to release him on probation of good conduct. Then, notwithstanding anything contained in any other law for the time being in force, the court may, instead of sentencing him at once to any punishment, direct that he be released on entering into a bond with or without sureties to appear and receive sentence when called upon during such period, not extending 3 years, as the court may direct, and in meantime to keep peace and be of good behavior, provided that the court shall not direct such release of an offender unless it is satisfied that the offender or his surety, if any, has a fixed place of abode or regular occupation in a place over which the court exercises jurisdiction, or in which the offender is likely to live during the period for which he enters into the bond. Before making any order under subsection so and so is made, the court shall take into consideration the report, if any, of the probation officer concerned in relation to the case. When the order under subsection 1, the court may, if in its opinion that in the interest of the offender and of the public, it is expedient to do so, in addition, pass a supervision order directing that offender shall remain under the supervision of a probation officer named in the order during the such period, not being less than 1 year, as may be specified herein, and may in such supervision order to impose such conditions as deemed necessary for due supervision of the offender. The court may, making a supervision order under subsection 3, shall require the offender before he is released to enter into a bond with or without sureties to observe the conditions specified in such order, and such additional conditions with respect to residence, abstention from intoxicants or any other matter as the court may, having regard to the particular circumstances, consider fit to impose for preventing a repetition of the same offence or commission of other offences by the offender. And the court, making a supervision order, shall explain to the offender the terms and conditions of order, and shall forthwith furnish 1 copy of the supervision order of the offender's sureties, if any, the probation officer concerned. So this under section 4, here, your Lordship, the person was allowed to go on probation.
Where is that order?
That order, your Lordship, will find at page 72. It starts from the appeal, it starts from page 48. The order is at page 72. Initially, he was convicted under section 409. Now, the conviction was converted to section 406 and he has been given on the provision. 72, para 26 and 27. As the accused was a peon in grade 4 employee, instead of convicting him under section 409 IPC, I would like to modify the sentence of the learned trial court and convict the accused under section 406 IPC, which penalizes criminal breach of trust. The malfeasance has been proved. The infraction of the payment by the accused has been proved. The accused was entrusted with the dominion over property and he dishonestly misappropriated the same. Thus, the accused committed criminal breach of trust. The ingredients required to prove an offense described under section 405 of the IPC has been proved. The decision of the learned trial court was appropriate. Considering the fact that the accused returned the entire amount to his employer, I believe a sentence of imprisonment is not required. I would like to resort to section 4 of the provision of the Probation of Offenders Act, which will be executed by the trial court. The accused is thereby convicted under section 406 of the IPC and released on provision of good conduct for a period of 6 months. Thereafter, he was not subsequently convicted. Now, what has happened after this, Your Lordship? He made the application to the authorities concerned. Now, that application, Your Lordship will find that, Your Lordship, will see at page 76. Here, what has happened, Your Lordship? He was asked to then submit the orders of the court. After that, he was issued the show cause. That show cause, your notice, was on 22nd July 2019. This is where Your Lordship will see two things have happened, because the order of provision was given on 30th day of June 2016 and the show cause was issued on 22nd July 2019, 3 years thereafter. Now here Lordship will see at page 83. Till here, Your Lordship, matter was basically okay, because this was so cause on 22nd July 2019, 83 Annexure 15. Whereas you were suspended from service on so-and-so, while this office order dated so-and-so pending departmental proceeding, following GR case number due to arrest by police on so-and-so on the basis of FIR submitted by the chief manager, so-and-so bank, for misappropriation of government money and in jail custody for more than 48 hours. And whereas you are convicted by the trial court, Honorable Chief Marshal Karimganj, and appellate court, Honorable District Session Judge Karimganj, in criminal appeal with modification of sentences under section 406 for breach of trust. And whereas you have prayed for reinstatement in service by petition dated 15/5/2017. So under the above circumstances, you are directed to explain and show cause, being a government employee, as to why disciplinary action under the provisions of so-and-so rules as well as other rules should not be taken against you for negligence in government duties and conviction by court for criminal breach of trust, misappropriation of government money, etc. Your satisfactory explanation regarding the matter in writing or personal appearing should reach the undersigned within 7 days from the receipt of the notice, so-and-so. Then, Your Lordship, he made the reply, that is at page 85. He made a reply to that, Your Lordship. Now what has happened, Your Lordship? After the reply, the enquiry and departmental enquiry did not proceed. This order at page 88. This was on 23rd of June 2020. This has the approval of the Honorable Mr. So-and-so. In the instant case, Sri so-and-so has not only been convicted by the learned Subjudicial Magistrate Karimganj, but also conviction has also been affirmed by the learned Session Judge through the learned Session Judge Karimganj modified the sentence. Further, Sri so-and-so has been convicted for misappropriating government money. Therefore, Sri Deepak Dey should have been dismissed from service after he was convicted by the learned Subjudicial Magistrate without waiting for filing of appeal by him. Therefore, as the conviction has been upheld by the Session Judge Karimganj, the question of his reinstatement does not arise, and in view of the provisions of clause so-and-so of Constitution, Sri Deepak Dey may perhaps be dismissed from service without any enquiry. So after that, Your Lordship, this order, then they have passed the impugn order, that is at page 91. That is 7th of July 2020. As directed by the Director of Economics and Statistics Assam, by number so-and-so, so-and-so, dated 25 June with reference to the government of transmission so and so, dated so and so,
He did
subject.
not file any appeal against the conviction.
No, I filed the appeal against the conviction. In the appeal, your lordship, the sentence has been modified to provision.
But a conviction,
Conviction from 409, it was converted to 406. Now, and that is whether it was converted from 409 to 406, criminal breach of trust. So under that section, the conviction was upheld. But I was given, since I have already returned the money, so there was whatever the court said, on that basis of which I was given provision under the provision of offenders. Now, if I am given provision of offenders as under section 4, then section 12 will have. Now, section 12, I have already read, your lordship. Section 12 says that if I am granted provision under the provision of Offenders Act, then, your lordship, I shall not suffer disqualification. Now, this is the question which is to be decided now, whether under such circumstances, automatic disqualification can be done, or there has to be a procedure under section 311, article 300. This is what the question will arise now. Now, their case is in their affidavit also. I'll just point it out to your lordship. Both the respondent number 1 and the respondent number, I think 4, have filed their affidavit. In the affidavit of respondent number 4, they have specifically stated that after the show cause, I was removed as because the inquiry was not required, that was given by the government, and order was passed, so we have removed him. And the respondent number 1 in his affidavit has stated practically the same thing. Since, your lordship, it stated that he petitioned this part which was read by me, that he should have been immediately dismissed after he was convicted by the lower court, before he files an appeal before the trial, before the appellate court. He should have been dismissed. Since he has not done so, that has not been done at that point of time. Now there is no need for any further inquiry, so he has to be dismissed. This is what both the affidavits are. I'm not reading that all through the affidavit. The gist of what they have made out in the affidavit, I am saying. Now, your lordship, the question is this: whether disqualification will lie when there is a conviction, and if the conviction is still upheld and the provision has been given to the person under the provision of Offenders Act, whether section 12 will be applicable or not. That is the only question. Now, for that, your lordship, I have to rely on a few judgments of the Honorable Supreme Court as well as this court, where this point has been discussed and decided. First, your lordship will take up the judgment of the Honorable Supreme Court. उल्टा-पुल्टा quit হলো না judgment. ये दिल्ली में तो तुम्हारे होटल लोग कब लोग Xerox कोई सकता है. Just a moment, boss. না হেভি জাজমেন্ট করতে হবে. ঠিক হলো না এরকম জাজমেন্ট. Yes, 1975 Supreme Court, your lordship, 221 Khondia. Fully delay क्यों मुझे papers? Alright. Yeah, piece of piece की report. हाँ, यहाँ पे तो petition ही है.
Judgment report, where is the whole judgment? This is only the heavy. Report মানে
You have your judgments.
Yeah, I have a judgment. I have just given them to get a copy of them. Now it is like
You can have it. You get your judgments ready, we'll have it.
that is an old judgment, but specifically on this point. দুটা বেলেগ বেলেগ কৰি দিছে আপুনি একেলগে এটা ষ্টেপৰ মাৰি দিবা হা This is a very old judgment, 1975, Supreme Court. Here, your lordship, this specific point has been discussed. That is why I have taken out this judgment. There are subsequent judgment and also judgment of this honorable court. I'll come to that. This is
ये दे दीजिए ना नहीं
yes, sir, but
क्या बोलते हैं
like
इसको?
a judgment of first certificate development.
hand up
You can go take on confusing.
Yes.
Yes. In this judgment, your lordship will kindly take up para 9. I'll rely on 3-4 paragraphs. In the instant case, we are concerned only with so-and-so clause, which does, notwithstanding anything contained in Rule 9 to 13. Where this is with regard to that case, particular case, but it has come to the finding with regard to what should happen in a provision. This is why I'm reading it from the beginning, from 9. Where any penalty is imposed on a railway servant on the ground of conduct which has led to his conviction on charge, the disciplinary authority may consider the circumstance of the case and make such orders thereon as it deems fit. The word penalty imposed on a railway servant, in our opinion, does not refer to a sentence awarded by the court to the accused on his conviction, but though not happily worded, it merely indicates the nature of penalty imposable by the disciplinary authority if the delinquent employee has been found guilty of conduct which has led to his conviction on a criminal charge. Rule so and so appears expressly contains the procedure for imposing penalties. Furthermore, so and so enter procedure for holding a departmental inquiry. Rule so and so give details regarding major and minor penalties. Finally, so and so seeks to incorporate the principle contained in proviso A to Article 311(2) of the Constitution. Thus, no person as aforesaid shall be dismissed or removed or reduced in rank except for an inquiry in which he has been informed of reasonable opportunity of being heard in respect of those charged, and where it is proposed after such inquiry to impose on him any such penalty until he has been given a reasonable opportunity of making representation on the penalty proposed, but only on the basis of evidence adduced during inquiry, provided that this clause shall not apply where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction in criminal charge. An analysis of the provisions of Article 311(2) extracted above could clearly show that this constitutional guarantee contemplates 3 stages of departmental inquiry before an order of dismissal, removal, or reduction can be passed, namely, 1, that the receipt of complaint against the delinquent employee charges should be framed against him and a departmental inquiry should be held against him in his presence, and after the report of the departmental inquiry received, the appointing authority must come to a tentative conclusion regarding the penalty to be imposed on the delinquent employee. And 3, that before actually imposing the penalty, final notice to the delinquent employee should be given to show cause why the penalty proposed against him be not imposed on him. Proviso A to so and so, however, completely dispenses with all the 3 stages of departmental inquiry when an employee is convicted on a criminal charge. The reason for the proviso is that a criminal trial, the employee has already had a full and complete opportunity to contest the allegations against him and to make out his defense. In the criminal trial, charges are framed to give clear notice regarding the allegations made against the accused. Secondly, the witnesses are examined and cross-examined in his presence, and
and by him. And thirdly, the accused is given full opportunity to produce his defense, and it is only after hearing the arguments that the court passes the final order of conviction or acquittal. In these circumstances, therefore, if the conviction by a court, a fresh departmental inquiry is not dispensed with, it will lead to unnecessary waste of time and expense and a fruitless duplication of the same proceedings all over again. It was for this reason that the founders of the Constitution thought that once the delinquent employee has been convicted of criminal offense, that should be treated as a sufficient proof of his misconduct, and the disciplinary authority may be given the discretion to impose the penalties referred to in 311(2), namely dismissal, removal, or reduction in rank. It appears to us that proviso A to Article 311(2) is merely enabling provision. It does not enjoin or confer a mandatory duty on the disciplinary authority to pass an order of dismissal, removal, or reduction in rank the moment an employee is convicted. The matter is left completely to the discretion of the disciplinary authority, and the only reservation made is that departmental inquiry contemplated by this provision, as also by the departmental rules, is dispensed with. In these circumstances, therefore, we think that Rule 14, one of the rules so-and-so was incorporated and principle enshrined in the proviso so-and-so to Article 311(2) of the Constitution. The words where any penalty is imposed in rules should actually be read as where any penalty is imposable, because so far as the disciplinary authority is concerned, it cannot impose a sentence. It could only impose a penalty on the basis of conviction and sentence passed against the delinquent employee by a competent court. Furthermore, the rule empowering the disciplinary authority to consider circumstances of the case and make such order as it deems fit clearly indicates that it is open to the disciplinary authority to impose any penalty as it likes. In this sense, therefore, the word penalty used in so-and-so is relatable to penalties to be imposed under rule rather than penalty given by a criminal court. Another important aspect of the matter is that a criminal court after conviction does not impose any penalty but passes a sentence, whether it is one of fine, imprisonment, or whipping, or the like. The penal code has been on the statute book for a large number of years, and the rulemaking authority was fully aware of the significance of the word conviction and sentence. And if it really intended to use the word penalty as an equivalent for sentence, then it should have used the word sentence and not penalty. In any circumstances, we are satisfied that the word penalty has been used in juxtaposition to the other connected provisions of rules appearing in the same part. The view of Kerala High Court before the magistrate released the delinquent employee on probation, no penalty was imposed as contemplated by so-and-so, does not appear to us to be legally correct and must be overruled. Nevertheless, we would uphold the order of the Kerala High Court on the ground that the last part of so-and-so, which requires the consideration of the circumstances not having complied by the disciplinary authority, the order removal of service of the delinquent employee was lightly quashed. This brings us to the consideration of two interconnected questions, namely as to what is the effect of the order of the magistrate releasing the accused on probation and the effect of Section 12 of the Provision of Offenders Act. It was suggested by the respondent that if the magistrate does not choose, after convicting the accused, to pass any sentence on him but releases him on probation, then the stigma of conviction is completely washed out and obliterated. And therefore, rule so-and-so will not apply in terms. We are, however, unable to agree with the somewhat broad proposition as per perusal of the provisions of Provision of Offenders Act so-and-so clearly shows that a mere fact that the accused is released on probation does not obliterate the stigma of conviction. The relevant portion of Section 3 of so-and-so hereafter referred to as the Act runs as under. So this is what has been stated in Section 3 of the Provisions of Offenders Act. Then Section 9 of the Act has also been quoted, Your Lordship.
And so what is it that you want to submit before the court?
The question is, once the Provision of Offenders Act, a person is released, he is not sentenced. Therefore, now I'll come to that in the next two paragraphs. Therefore, he is not entitled to be disqualified from this service. That is first one. If at all there has to be a disqualification, if the department wants a disqualification, then there has to be a procedure of Section 311. That means he has to, so cause notice has been given, subsequent reply has been given. Thereafter, he was dismissed without conducting an inquiry. Here, the inquiry should have been conducted, and then if he has been found to be dismissed or removed or whatever reduction in rank or so, that should have been done. Then it would come to the penalty. He should be given some penalty for that. Now, what they have done, just because there was a conviction, and though he was given the under provision, he was released under provision without being sentenced in the appellate court. Then even then, on that ground also, he was dismissed from service without going into the inquiry. This is what happened in this case, and therefore, Your Lordship, in para 12, the court has stated now in the judgment I have referred to. Now,
this will require some hearing.
yes,
Keep it for a hearing date. Heard counsel for the parties. That will be listed for hearing.
we're gonna get
19th,
Lordship.
19th.
Item 53 and
Answer.
54.
Yes, what is these hearing matters?
Actually, what I mentioned, I tick mark in the order column. On
I
last.
don't know.
That one.
It is shown as
What's my list it on a hearing date.
what is your grievance?
My previous watch. Was it, I was appointed by the irrigation department of it, the Karbi Anglong division of it, on 21/5/1991.
What is your, what do you want in this report?
Lordship,
What is your prayer?
setting aside of Lordship Annexure 8.
What is Annexure 8?
Annexure 8 Lordship, place 38 times the value of Lordship. And my pension proposal was returned by the nodal officer pension cell Lordship.
Thirty-eight.
38, place 38. Lordship.
This is only a communication for returning.
Lordship.
Why are you challenging this?
Lordship, I was appointed in the year 1991.
Your claim is for grant of pension.
Pension.
Yes, pleadings completed.
Complete Lordship.
What are you doing? 22 matter, why have you not filed your affidavits?
Irrigation department has already filed also.
You are employed under which?
Irrigation department.
In Karbi Anglong.
Karbi Anglong division.
So what has Karbi Anglong got to do with it? Who is to release your pension?
Parent department, irrigation Lordship. Karbi Anglong Autonomous Council also involved also.
Yes, why affidavit not filed? Huh? Instruction not received. Yes, Mr. Sutia, 3 years, no affidavit.
Without affidavit, it can be decided. The matter is covered by the division.
Which division bench judgment?
Upendas.
Upendas. You are what, master role?
Work charge Lordship.
Work charge.
I was work charge Lordship.
You want pension,
Pension Lordship.
but you'll have to be regularized.
What happened, Lordship, there is already a mandamus issued by the Honorable Court in the year 1993, directing my regularization.
What happened after that?
That order has attained finally, Lordship. Hereafter,
Were you regularized in pursuance to that order?
no, Lordship, subsequently I was reappointed. The youngest pursuant to order of this honorable court.
Have you been paid the minimum of wages?
No, Lord.
Yes,
Minimum wages. My lord,
Upendas.
my lord, all these points, my lord, earlier the petitioner approached this court. The court directed to frame a policy, my lord, for absorption. The government has framed a policy and they placed it before the division bench. And division leave was sought for, leave was not granted by the division. All these points have been discussed by the division bench in the Upendas case, my lord. And it has been decided that only to direction to pay the, my lord, the minimum basic pay, and they are not entitled to pension. That point has already been decided.
Lordship, in terms of the judgment, first one of apex court in the case of Nilima Srivastava, as well as in the case of Nilima Srivastava, Lordship, as well as in the case of ML Kesari, I am entitled, Lordship. I'll satisfy your Lordship.
No, you can't satisfy like that. Then you'll have to file, you have to urge that Upendas needs to be reconsidered. This is a judgment of this court, division bench. It can't be tossed aside like that.
Because there is already a mandamus, Lordship. By the
That
honorable court.
mandamus was not followed, then you should have filed a contempt. That was not filed.
Lordship, because the order was partly complied, Lordship, I was the youngest, that's why contempt was not filed. So, Lordship, but
Order
kindly
of the
fix it, hearing the
singular,
Lordship.
my lord, order of the singular is that, my lord, to frame a policy and to, while absorbing the petitioner on a regular basis, age bar should be revised and reservation rules shall be complied with. That is the order.
We'll call up again on 28th of August for hearing.
We'll file a short affidavit also, my lord.
You may file if you want. 28th of August for hearing. The Karbi Anglong Autonomous Council may file their affidavit in the meantime, if so advised. Yes. Mr. R. Boro for 6.
In 1852.
In 54. T.S. Neo for irrigation. Yes.
Lordship, my senior on lakes in another court, Lordship. He will come, Lordship.
The request made by the counsel for the petitioner, matter stands passed over. MS R. Decker, case for
Okay, that is an empowerment.
the social justice and empowerment. And a day for N day for respondent for. Yes.
Lordship, as per Lordship direction, today only I have received a order copy. Lordship may allow me 10 days time. I'll produce the record.
Ah. 10 days on the request made by the counsel for the petitioner for the respondent, matter stands deferred to be listed after 10 days. Mr. A.F.N. Mullah appears for the petitioner. Matter be listed on a after 10 days. 28th of August. We have passed over. Let it come on 28th. We are fixing these matters on 28th August. Hello?
Order to go there and achieve.